Good morning, everyone. Good morning. This is a regularly scheduled meeting of the Town of Fort Myers Beach Local Planning Agency. All members are present. And it is February 11th, 2025, 9 a.m. If you could please stand to the invocation and the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Oh, let's see. Well, with Valentine's Day on the horizon, let's all remember to be kind and good to each other and our community. Amen.
Amen.
May I have a motion, please, for an approval of the final agenda, unless anyone wishes to make any changes?
So, second.
Thank you. Thank you to the two Jims. Is there any discussion? Hearing no discussion, any objection to that motion? And hearing none, the motion carries unanimously. The next is an approval of the minutes for the local planning agency meeting of January 9th, 2025. Does anybody have any corrections? There is one little one on page 11. Does anybody else have anything else? I think they refer to CPD, let me just find it. It's a Scribner's error. It really is nothing, so I could let it go. It's just they don't have the LPA correct. Well, if nobody else noticed it, I'm gonna leave it alone. May I have a motion to approve the minutes? It really was nothing.
So moved, Sutton.
Thank you, Don, and thank you, John. Any discussion on the motion? Hearing none, any objection to the motion? Motion carries unanimously. Thank you. Okay, so the next item is public comment, but this is public comment for any item that is not on the agenda, no, that is on the agenda, but if you want to speak for a hearing, you should wait until the hearing. Okay, does anybody have anything, you just want to say? No? Okay, thank you. Next item is, the first item is a variance, and this variance is for 7205 Estero Boulevard. I'm going to read the title, and then I'll ask for ex parte and all of that, and Nancy will give her speech. So the title is, a resolution of the Town Council of Fort Myers Beach, Florida, approving with conditions, or denying a variance for the property located at 7205 Estero Boulevard, generally identified as strap number 034724W10011.0000 in Fort Myers Beach, Santini Plaza, to allow a multi-unit complex to develop individual unit signs that are a maximum of 32 square feet, as well as developing a 32 square foot ground sign to display the complex name and branding, allowing for the structure to be developed on the property line, providing for other clarifications as necessary, providing for conflicts of law, Scribner's errors, severability, and providing for an effective date. Could I have ex parte, Jim?
None.
How about you, Don?
None.
Doug?
No, ma'am.
Jane? Jim?
None.
Done.
John? And I have to recuse myself, and I have filed the report with Amy because, as most of you know, I have a business there. And it will be impacted.
Okay,
Okay, Nancy.
thank you. So,
Welcome.
thank you, Madam Chair. So, the variance as well as the CPD that is on your agenda today, both of these are quasi-judicial in nature. And this requires that the hearing for both of these items complies with procedural requirements that have been established in Florida law and in our land development code. So today your public hearings will be less formal than if you were before a circuit court judge, but they will be a little bit more formal than typically when we have discussion of other items. We must follow basic standards of due process, and that requires that certain items be provided notices, the application of the correct standards, and that your decisions are made on competent and substantial evidence that's presented to you today in written documents or through oral testimony. So your job, your responsibility today is to evaluate that testimony and the information for each of these two items, and then draw a conclusion regarding whether the criteria that is in your land development code or in state law has been satisfied. So pure speculation or mere opinions that is not based on competent facts legally cannot be considered by you in evaluating an agenda item. Testimony by professionals who are qualified, who you believe are experts in a particular area, has been considered competent evidence by Florida courts, as well as testimony by neighbors and residents who have fact-based information such as minutes, surveys, engineering reports, or testimony that is based on their personal knowledge and experience. So, members of the audience, of the public, if you intend to speak, please keep this in mind. And when you come forward, please state your name clearly for the record, whether or not you have been sworn in. You do have a variance on your agenda today. And just a reminder, a unanimous decision by eligible voting members of the LPA to approve the variance shall constitute final agency action subject to a request by anyone for an additional hearing or review of the matter by the town council if that request for the additional hearing is received by the town clerk within 10 days. So for purposes of efficiency, we want to go ahead and take care of a few housekeeping items. I first need to ask the town clerk whether or not the two items have been properly noticed for today's hearing.
Yes, they have been.
Okay. And also, at this time, if there's any LPA member who has a conflict of interest, as our chair has disclosed, this is the appropriate time to also make that disclosure. Does anybody else have a conflict on any of the two? Okay. And the chair has indicated that she has already filed the Form 8B. And at this point, Madam Chair, it would be appropriate to go ahead and swear in the witnesses.
Thank you. Should we do both at once?
Everyone.
Yes, I think everyone that is,
So if anybody intends to speak at either one of these cases, would you stand now to be sworn in, please?
If you think you might.
If you think you might. And you know what?
You
If
don't
you're
have
on
to
crutches,
stand.
don't stand up. Don't stand up. Just raise your hand. Just raise your hand. We're gonna give you a pass on this today.
All right. Do you solemnly swear and affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? I do. Okay, everybody's been sworn.
Thank you all very much.
okay, I believe you did the ex parte disclosure
did.
on the variance. Do we know who will be participating for the variance?
Jason and Kara Stewart.
And for the record, Mayor, I believe, Mayor, I'm so sorry.
It's okay. it's
Chair, Mayor, kind of close.
Katie?
I believe Mr. Smalley as well as Kara Stewart have also been accepted as experts
Yes, they have.
for this
They have.
LPA.
Carrie Smith is here for the
And Nancy, before we go, could I just clarify one thing?
Sure.
We talked about this yesterday, but just so the
For
board
safety.
knows,
right here.
Oh, okay, I'm sorry. And we have Ms. Smith is here also for the applicant.
Carrie?
Yes.
Yes, yes.
Okay. Go ahead.
Even though I can't vote on it, I'm still able to discuss it and,
Be the chair.
she's not listening to me.
No, I am.
You're gonna move
I
her
am.
too?
Go ahead. Yes.
Be in the room.
She's going in the
There's
back
only four
room.
corners, so only one.
Anyway, I get to say something. Go ahead, Jane, Jason.
Chair, if you'd like, I
Yes.
can clarify that. So, on your 8B form, this applies to all of you, really, is that you are appointed to serve on this LPA, and although you must abstain from voting in situations, you're not prohibited from otherwise participating in these matters, but you do need to disclose the nature of the conflict, which your chair did, before making any attempt to influence the decision, whether orally or in writing, and whether made it for you at your direction. So,
Thank you. Go ahead, Jason.
Good morning. My name is
morning.
Jason Smalley. Good morning to LPA members, to staff. I'm with your Planning and Zoning Department. Before you today is a variance request for 7205 Estero Boulevard, otherwise known as the Santini Plaza. Under today's codes, individual units in a complex that has more than 2 individual units in it are limited to 16 square feet in size. The variance before you today is a request to expand that for each unit to allow for each unit to have a 32 square foot sign. And that would be in line with single and double use buildings under today's codes. The applicant has provided evidence to show that the general distance from the roadway is between about 98 to about 270 feet from Estero Boulevard. The staff has reviewed this. We agree that the distances are approximately that. But before you today is basically a request to allow for each one of those individual units to have the maximum 32 square foot sign. I would like to point out that staff has put a condition of approval in there asking you to discuss a maximum square footage on signage. The reasoning behind that is simply because we wanted to make sure that if the units were further split, so if they split a current unit into 2 units or 3 units, whatever will be allowed by code and fire department, that the entire fascia of the building doesn't become one unified sign that wraps all the way around it. So that's the reasoning for that condition of approval in there. Staff is here for any questions or concerns you may have, and the applicant's representative is here as well.
Thank you, Jason. Jim, questions?
Just a couple quick ones, Jason.
sir.
So, as your write-up indicates, the recommendation for a maximum, if you do the math of the current units, it comes out 600 and some.
Approximately, yes.
So I don't know where the 750 came from or your anticipation around that. So if you could just address that, that would be good since you're limiting the average per sign anyway.
So the 750 was really just a round number. It was to initiate discussion. So the addition on it was to accommodate an additional 4 units above the 19 that we're aware of in there currently. Really, this was meant to sort of initiate discussion. If you and the LPA believe that that is not viable or would like to have a higher or lower maximum number, staff is here for the discussion.
Just looking for the clarification, thank you for that. And then secondly, is there any distinction between how the signs, whether or not they're lighted or not? Does our code address that?
So not for the maximum square footage, but any signs that would be lit would be held to the same turtle standards and normal photometric standards in the code.
Okay, great, that's all I have. Chair.
Thank you, Jim. Don, questions?
No questions, thank you.
How about you, Doug?
I'd like to, just so we know, why is this request being made? I assume it's visibility?
Yes, sir. That's how it was presented to staff, is the building itself being between roughly 96 and 270 foot setback is much different than the pattern of development that codes today call for, and which most of the developments since 1996, when the codes went into effect, have required. So most new developments are going to be requested or required to push up the building, and therefore you would have a much clearer line of sight and it wouldn't be such a far distance. This building was developed in approximately 1977. It is what it is. It hasn't gone through many major changes, but the pattern of development was obviously different at that point, and they had either required or recommended that the building be pushed much further from Estero than more modern buildings would be required to.
Is
Doug,
is there signage like for the whole plaza, like saying, is there like a sign on the roadway?
I'm not aware of a ground sign, but we did make the point that the code already allows for an additional 32 square foot ground sign to accommodate the complex's name and its branding. So the owner of the complex may use that and then allow for the additional 32 square foot elsewhere.
I just wanted to, let me just add something for Doug. The other issue with Santini Plaza is how it is redeveloping. So where there used to be twice as many stores with half the square footage, there are now larger stores with, and, go ahead, Jane.
I think signage is really important, so I think from the street, that will really help people get directed once they get off. So, I have no other questions.
Any questions from you, Jim?
There is a ground sign at Linnell and Estero. now. Is that staying, because part of the letters are missing, do you know?
I wasn't aware that that was their ground sign, but if that is within the 32 square feet and they'd like to rebuild it, or as long as it meets the health and safety for site triangles, they could maintain that. That 32 square feet is an allowance that is separate than the allowance for each individual unit signage.
Like I said, there is a letter missing
There is
on it
another
now.
thing. John, any questions for Jason?
I do. Was there any discussion, as the Chair has pointed out, they're larger units, some of them now, and they have multiple facades, not just a single front. Was there any discussion of allowing multiple signs for some of the units?
So I believe it was sort of mentioned offhandedly, but it wasn't brought up to me by the contractor or by the consultant that is that's here today. There is a 90-degree or a perpendicular portion of that building. Under the way that the variance is written, every unit would be allowed a maximum of 32 square feet in signage. Staff did contemplate with the contractor or with the consultant for allowing the building owner to determine how much signage each individual unit would have, and so that may be still an option. But any building that has a frontage on 2 roadways there would still have a maximum of 32 square feet per unit under the resolution as it's written.
Similarly, was there any discussion of including a monument sign that would include a directory, if you will?
They could do that, but quite honestly, at 32 square feet, that probably wouldn't be enough to handle the approximately 20 units that might be in there. They might be very small. If the applicant wished to do so and develop that, absolutely. If the applicant wished to have an even larger sign, that would require a separate variance to allow for additional square footage.
Fair enough, thank you.
Okay, I don't have any questions, but I appreciate your work on behalf of all the tenants of Santini Plaza, Jason, I really do.
Thank you.
Thank you very much. Kara?
Katie?
I'm sorry?
Oh, go ahead. Sorry.
Kara Stewart, on behalf of Shaken Properties LLC. Good morning, Madam Chair and fellow LPA members. The questions that you all just asked were ones that I was going to be presenting as well. So in order to clarify on the number of units and how this new owner, property owner, is developing it, prior to the storm, we had approximately 31 units in this complex, much larger amount of stores and whatnot. We are now at 20, plus the ATM. We plan on staying in that format. The owner is a little concerned about the aggressiveness and the possibility that some of these larger units, if in time they need to reduce in size and we need to have in another tenant, therefore that additional 4 units that staff has proposed, or the square footage, 750, that gets us there. We're actually, and I did not have a chance to mention it to Jason, so we're actually looking for 800 square feet. We're looking to split the difference between what was there 30 units before. We have 20. Let's say if we need to go back to 5, I'm saying 800, whatever the actual number is, but that's what we were looking for, to be able to reserve in the event some tenant has an issue and we need to split up that unit and offer another space. The structure is such, in the way the units are laid out, the diagram that I had submitted is a little deceiving in a way. It doesn't give you the magnitude of the length of those structures and of those units. The 32 square foot, I mean, it's tremendous. I went down there this morning to double check myself, and it really is. It's going to fit quite fine. I think it'll look nice. It'll probably actually enhance the complex because it is more in relationship relative to what those fascias are. The fascias along all 3 buildings or 4 buildings, whatever they are, varies in height from like 2 to 4. We have some trajectories coming out. It really will probably look better this way than having little tiny signs over those 20 units. The issue on the ground sign, at this time, the owner, we're not asking for anything different. We're just really trying to accommodate our tenants and get them a larger sign. In relationship to the other comment that was made about the units that may have two frontages, so to speak, at this time, that is not in this request. If that tenant or those tenants choose to continue in that fashion, that will have to be addressed at a later time. The owner is not looking to correct that right now. So we're trying to keep it realistic, appealing to the road. As Jason had mentioned, when we had done our distances, we're 200 in some areas, 90 in some areas. You know, the code now, we're building 0 to 5 foot setbacks, much different effect with a 32 square foot sign along that road versus being so far away. The letter's missing on the ground sign. I'll bring that to the owner's attention, by the way, yes. And I think, unless there's any other questions for me, I'm hoping that addressed the questions.
Jane?
So the conditions for approval, you're in agreement with the three there, except that number 3, you'd like to change from 750 to 800?
If we could, yes, just for that extra, we're nothing against the tenants that are there. The town is going through a rebuilding, you know, I mean, there's that potential that someone needs to downsize what they've done. We also have, I just remembered too, there's an issue with, the landlord is trying to bring in larger businesses, and one of them is a hardware store. They have some requirements for larger signage than what is currently allowed, so that will help us with that particular tenant as well.
Okay.
Other questions for Kara?
Just one clarification, maybe I heard this wrong. Did I hear something during the presentation that the owner can still negotiate less square foot per unit than the 32 that we're allowing? That's between the tenant and the owner?
What will happen, correct, if you're given to the tenant the 32, if the landlord decides that they've got a narrower unit maybe and doesn't want to give them that, but the other issue is the 32 square foot can be split up amongst, like if a tenant wanted on that facade to have a sign, and then depending on if they wanted to place another smaller one on the back wall, they can. So that 32 is not necessarily just a given.
So
That's
further to
interesting.
that, there could be,
Not interesting.
there could be 2 signs, but a total of 32 square feet.
Correct.
Okay.
The code allows for that now. That's nothing
Yeah, I think
that we're asking for. That's just the way the code is.
like Sun Hardware. I think Sun Hardware, you could go to the back and see where
Correct.
the door was, and they were also on
That's
the
right.
front.
Correct.
But
before.
Kara, I don't understand this. The landlord has the option of dictating the size, so you all will hear from my neighbor Carrie. So if he likes Carrie more than he likes me, and he says, you know, I'm gonna give Carrie 32 square feet, but Anita, you can only have 20.
That's why I asked.
Yeah, so in other words, I get there will be some smaller spots where, you know, a 32 square foot sign, you know, might not work, and
Sure.
but I would think that this signage space belongs to the tenant or the business. That's how it should be allocated. I mean, that's how it's allocated every place else.
And then, I guess the other question would be is, could they do two 16 square foot signs on the front because they want one that says, you know, Nike or
Yes, they
something?
could.
You know, they want,
They
yeah.
could.
Okay.
They could.
So there you lose a little bit of the uniformity there
That's
too,
it. I was gonna
right?
say the same
So
thing.
if they're all kind of the same, that's one of the things I liked about
Me
it.
too.
Was, you know, instead of the little and the bigger and different, you know, if they were all uniform, to me that's the aesthetic that, you know, visible and aesthetically pleasing.
To maybe clarify that a little bit and to give some I don't know, some comfort with it. There are multiple sign permits that have been applied for right now, and they're using the larger square footage. That comment, it's in the code now. Any business can do that. So we're not looking to eliminate. We've not asked for that request. Let me put it that way.
Yeah.
So I'm just clarifying that we
Yeah,
have
I'm
not
not-
requested a deviation or a change from that section of the code.
Okay. Yeah, I wasn't concerned about the 32.
Mm-hmm.
I'm more concerned about the uniformity.
It is for a business entity. So business establishment, I believe, is the terminology used in the code that we're looking to stay consistent with. The language in the code is what the language is. We're merely asking today to be allowed to take a more than three and greater unit building, which is unique to the island, and allow those tenants to have 32 square feet. In a 2-unit building, you're allowed 32 square feet. So that was the only part of the code that we were addressing today.
Okay.
So to follow up on this allocation issue just one more time, so you went from 31 to 19. The current request allows you to go to 23 if you don't get the 800, 750. So you're going up about 25 or so on if the 800 comes? That's my math on, is that right, Jason? Well, I guess they'll ask you that.
Yeah, 25.
My math's okay on that.
It'd be 25 units.
Yeah,
That's
exactly.
32.
Correct.
So it would seem to me that you could represent that your intention to allocate the full 32, since you're asking for more and potentially more units, to anyone that requested as a tenant or owner. Couldn't that be on the record that the owners of the property, its intentions are to maximize the signs for each unit up to a maximum of 25 units? Because that's what your math would let you do. And that way you're not discriminating against, as one of the
Smaller
members put
business.
it, this person wants that one doesn't. But you know, I'm a lot more into bars than I am into women's fashion, so let's get a
That's
little
a
bigger sign
pity.
on that.
I think that's really, the
Jim
way the
Dunlap,
code
for the record.
would be interpreted, I believe, anyway, I can't speak for staff. You have separations, you have units that are established, right? So those units are the units that are established, those are what are represented to you today. The size of the units, for that additional square footage is just if those units become less. I'm not sure if I'm totally following the
You could
question,
use
so.
my store as an example.
Good.
It's 4,000 square feet right now. But if I decided to split it in half and either, give back 2,000 to the landlord so he could, it would stand to reason that that new 2,000 square foot store could also have a 32 square foot sign, which is your exact argument.
Exactly.
Which is correct.
That's okay with the math. I'm just trying to get to the motivation of the relationship.
That is
between the
correct.
owners and that.
Yep.
That
That
is
was
what the
motivation.
intention is, correct.
I'm glad we have that on the
Yes.
record.
Yeah, I'm also
is.
just, if I could just go back to I think of the ones that front Estero and Linnell. Was it Linnell? Yeah,
Linnell.
Linnell, yeah. I guess I don't know what we're asking. I don't have an issue if they had two 32 square foot signs, one on the front, one on the back, right? Because they might have two entrances, just by the nature of their unit, right? There's one that has actually 3 sides, right?
That may come forward at some later time, I don't
Okay.
know.
Okay.
Right
Right, okay,
now,
yeah.
It's not
we
an
are
ask
not
question.
dealing
Okay.
with that
Understood.
particular scenario
Okay.
that we're referring to.
Okay,
Thank you.
thanks.
Any other questions for Kara?
I'm good,
John?
thank you.
Jim?
No.
Jane? Doug?
No, ma'am.
Okay. Thank you
you.
very much, Kara. Okay, I know Carrie's here to speak, but she's a public comment on this topic. So we'll ask for public comment. Carrie, come on up. This is my neighbor, Carrie.
No pressure.
Carrie owns Leonie's right next door to me.
Hello. For those of you that don't know, Leonie's has been there since 1977.
Carrie, say your name for the record.
Oh, I'm sorry. Carrie Smith, owner of Leonie's, Santini Plaza. Anita's neighbor, for the record. Full support of the island maintaining aesthetics, maintaining everything that we want to do here. But in the big picture, Leonie's has been there since 1977. Whether we have a little tiny sign or a big sign, we are going to survive. But no one's been through what it is this island has been through. And now's the time to do some correction because we have the opportunity to do the correction. So if the rest of the world is doing a certain conformity, now's the time for us to do the certain conformity and leaving it to the landlords. And Anita's 100% correct. My store is the same. If I decided I wanted to give a little bit back, then I need to give some of my signage space back. I have room of my, let's see, that would be 50 feet of frontage. Well, that means I have to scoot over and stay within my 25 feet of frontage because I'm giving back and I have to allow my neighbor. That's common sense. We don't have to nitpick it to death. Any?
Thank you for being here, Carrie.
Thank you for all your help.
Appreciate you. Anybody else like to comment on signage at Santini Plaza? All right, public comment is closed. Any further discussion or questions for staff or the applicant?
Jason, do you have any objection to increasing the 750 square feet to 800 square feet on section 4?
I don't have any professional concerns about that change in number.
Just to follow up to that, are there any significant inconsistencies that are created with that allocation versus others on the island?
No, I think the 800 square feet across all of the units is reasonable.
Any other questions or comments? Any discussion? If not, may I have a motion, please?
I'll make a motion to approve the variance, finding that it meets all of the findings and conclusions with 3 conditions attached. One change on number 3 from 750 feet to 800 feet.
Second.
Okay, there's a motion. Is there any discussion on the motion? Hearing none, I'll call for your vote. Jane?
Aye.
Jim?
Aye.
John?
Aye.
Doug?
Aye.
Aye.
Don? Jim?
Aye.
Thank you all.
And just a reminder that this is a unanimous decision by the eligible voting members of the LPA, and this is final agency action, subject to a request by anyone for an additional hearing before the town council that must be received by the town clerk within 10 days.
Thank you very much. Thank you, Carrie, and thank you, Kara.
Thank you.
Okay, so we'll move on to the next hearing, which is what most of the audience is here for. This is DCI 202-40137.2, a mobile vending food truck park CPD amendment. This is an ordinance of the Town Council of Fort Myers Beach, Florida, approving with conditions the commercial plan development, CPD, zoning for the property located at 2500, 2510, and 2518 Estero Boulevard, and 2543 Cottage Avenue, generally identified as strap numbers 194624W30120A.0100, 194624W3013020.0000, 194624W3013001.000, 194624W30120A.013A in Fort Myers Beach. 2, allow a mobile vendor food truck park with shared parking, providing for other clarifications as necessary, providing for conflicts of law, Scrivener's errors, severability, and providing for an effective date. So we also have a request from the Pelican Watch Association for several people to have intervenor status. So the first thing I'm gonna try and do is wrap our heads around our time factor here, okay? So, Ken, would you stand up for a second? I spoke with Patrick yesterday. He told me you're gonna need about 20 minutes. 20 to 30 minutes? 30 minutes, yes. Okay, so so I know how much time to give the interveners, if we qualify you. So Nancy, do we need to ask for the interveners to come forward first?
Yes, you have a couple, because of the, we typically don't have interveners or affected parties requesting participation, an opportunity to participate. So we have a couple housekeeping items that we will need to address prior to the actual beginning of the presentations. So the first will be whether or not you believe that the individuals who are requesting intervenor status actually satisfy the criteria and are intervenors. This would be individuals, and they'll explain more, who have a greater interest in your decision than typical members of the public for the reasons that they will present. As your chair pointed out, intervenors typically are allowed to participate in quasi-judicial hearings, but they don't quite have the same property rights at stake as the petitioner does, because the application clearly impacts the petitioner. So for that reason, they typically get a little bit less time to do their presentation. In this particular agenda item, there has been a number of documents that have been submitted prior to the distribution of the agenda, which you received. Oftentimes, we do take a separate vote to allow documents into the record. I think that before we actually get into the presentation itself, that the LPA should give some direction as far as what documents you are considering in the record. And lastly, the other thing I think we need to take care of at the beginning would be, there was a number of individuals who were sworn in, some of which may be experts. So perhaps it would be best to go ahead and see who's going to be testifying as an expert, hear their qualification, and take a vote as to whether or not you consider them
Okay.
to be an expert.
Madam, if I have one
Yes.
clarification, can you, for my purposes, create a distinction for me between an intervener and an expert witness?
The intervener is the person or entity that actually has a property right that could be affected by the decision that's made. The expert witness is a professional who has expertise in a particular area that might be relevant to
Right.
that.
I guess I missed the part about property rights. I was thinking back to the pink shell intervener we had. Didn't know that gentleman had property rights with that particular property. I didn't consider that when we were looking to intervener status, so subject matter expertise matters. That's why I'm asking about the whether or not they can be an expert witness or not versus an intervener, or can they be both? But if they have to have some property connection to be an intervener, that's a distinction that matters then. Okay, thank you.
Thanks, Jim. Okay, so who is going to, hello, Mr. Davies, who is going to be testifying as a witness, as an expert? And so both of these gentlemen are attorneys.
That is correct. I believe they're prepared to discuss the intervener issue, but I think, I agree with you that perhaps going ahead and qualifying who's gonna be experts, that would be satisfactory as well.
Okay?
Should we also do ex parte?
Yes, we'll do, yes.
Once we begin
Yes,
the
let's
hearing,
get these
yeah.
guys out of the way first, okay?
All right, so who's gonna be experts?
We'll decide.
Just to enter my name into the record, David Moscoso, Becker, and Polikoff here on behalf of Pelican Watch, Tom and Deb Danford, and Ed French, who are residents abutting the proposed project. So I've got three experts with me today: Max Forgy, Mohsen Salah, right? Salehi,
Oh.
and Matt Simmons.
So nice to see you, Moses.
And just one real quick question for clarification on with regard to time. We are certainly happy to yield as much time to the applicant as we are, intending on having. We've got a number of residents here today who I think just on the 3 minutes allotted of time that each of them would have would exceed the 30 minutes that the applicant is intending to take up. We have no problem with them taking up more than that time. And I would ask that in lieu of having a strict 30 minutes for us, because our experts have worked on so
David,
many.
that
Yeah.
has nothing to do with you. That only had to do
Okay.
with the interveners.
Got it. Okay, great.
It has nothing to do with you.
Okay, thank you. I appreciate that clarification.
welcome.
And
You're
then,
welcome.
and finally, for the interveners, if their time could be counted separately from our time as,
It's, your time doesn't have a limit.
okay, great, thank you.
And it is, but just remember, less is more.
Sure, of course. Certainly.
It's not like Christmas where
Yeah,
more
yeah.
is more.
Sorry to interrupt. I'm Noel Davies. I represent the applicant. David represents the intervener.
That's correct.
Interveners.
Correct.
That's correct, yeah.
Okay.
Correct.
So
You need to come to the.
I've got that straight. I've got
Okay.
that straight.
so applicant does have a limit on time.
Applicant,
He has
no,
to come to the
listen,
microphone.
both, Noel, come up here,
Yes.
so you're both on the record. This is
I don't know
Noel
if this is-
Davies.
I don't know if this is on.
Uh,
record.
Noel,
It
for the
is.
record, Noel Davies on behalf of the applicant.
Thank you. The only thing I was trying to do was kind of wrap one of our members has to leave at noon. He's a valuable member, not that everybody isn't. But,
Thank you.
you want everybody here for this case, as was seen in the last case. So I'm just trying to wrap my head around yesterday what our time is gonna look like in this. So I made a call to say, hey, Patrick, Ken, how long are you gonna need? Because Ken can be long-winded.
Yes.
And, which is all right, that's his prerogative, but we have, one of our people are gonna leave at noon.
Okay.
So, that's a heads up. And so that's why I was trying to get my head wrapped around
Okay.
time, okay?
Okay, great.
Not to crunch any of you, but just to advise you,
Sure.
all right?
Yeah, go ahead.
And then as far as the interveners are concerned, the interveners are allowed, I just really dislike interveners, it sounds, ugh, and these are good people. They are allowed more time than the general public coming to speak, which has 3 minutes, but trying to decide how much more time.
Right.
I wanted to get an idea of how long the applicant would take, so I could make that accordingly.
Okay.
Okay?
And our plan, just because we've got, I think, you know, these experts who have such valuable information,
Sure.
internally, what we discussed was be prepared to maybe limit it to, you know, 10 minutes, an expert. You know, I think we could probably do this a lot more substantively and take up much more time, but out of respect for everyone's time, we would request 10 minutes for each one of our experts so that they could really get into, I think, some of these
That's
substantive
that's
points.
up to you. That's
Sure.
up to you.
Thank you,
Okay.
I appreciate it. Thank
Yes,
you.
sir, you're welcome. Noel, any questions?
Yeah, I just wanted to add, and thank you, Madam Chair, that, so, my client and our team, we're happy to do whatever, however you wanna run this hearing today. I wanna get that out there, and we would defer to the will of the majority of LPA on expert status, intervener status, however you all wanna do that.
Thank you.
I will preview that I've also got to, because there's attorneys involved, note certain things for the record.
Of course.
So we do object to them having some sort of special status. As you mentioned, you know, just like any of your hearings, there's a right to participate in public comment. We are happy to limit our time, 30 minutes, hopefully less.
Wasn't asking you to limit, just asking you to give me an
The-
idea.
the
I
i-
don't want you to
sure.
feel like I'm limiting you.
Sure. But I guess my point is that, just because they're asking you for this extra status, doesn't mean you have to grant it.
Oh, we know.
If you wanna do that, that's your prerogative, but we object to any other status other than them presenting as regular members of the public.
Okay, well, thank you for that. Thank you. All right. Nancy?
And also, so kind of getting back to some of the issues, the housekeeping matters before we delve into the substance of the application. So the first thing that is really in front of you is whether or not to afford the individuals with their attorney representing them intervener status, and there should be a little bit of debate on that. And that is only intervener status for the purposes of this administrative review of the application.
So should we call them up?
I think it would be appropriate,
Okay,
yes.
so, Mr. and Mrs. Danford, are you here? I mean, obviously you're here. Could you guys come up? I was trying to remember who you were, and now I remember who you are. Okay, so Nancy, go ahead.
Are you being represented by counsel?
Yes.
Okay, so if you would like, if we can, allow their attorney to present their request and
Could
the
I ask us a
basis for
strange
it.
question? If you're being represented by counsel, why do you also wish to have, why the intervener status if you have counsel?
Sure, if I may.
Please?
I think it's important for them to express their concerns as residents that are a little bit less than technical, a little bit less than rooted in kind of policy and the law. I think there are a lot of aspects of their experience and the impact of the item being considered before the board that are unique and nuanced and very specific to people who live in the neighborhood.
Okay.
And so I think the arguments that I'll make and the information that I'll be providing to you, a little bit, you know, a little bit of a higher level and a little bit less personal, so that's the basis for it.
Okay.
Thank you.
So David, could you
Yes.
perhaps make the presentation, the request,
Sure. In-
asking for the intervener
Sure,
status?
yeah, so I would ask for intervener status for Tom and Ded Danford, for Ed French, and for the Pelican Watch Association, Randy Brysett.
And the reason for it?
And the reason for it is because of the fact that they are, you know, residents who are immediately impacted. Number one, they abut the lot, all of the folks that I've mentioned that I'm requesting intervener status for directly abut this property. The comments that they need to make and I would like for them to make and they would like to make are much more nuanced and much more specific and unique to folks who directly abut the property and are not necessarily comments that folks who maybe live in the city and care about the city deeply in terms of its policy and its planning would have the ability to make, and they're not going to be impacted by in such a deep way. So my request is rooted specifically in that.
Jim, you have a question on
Nope,
this?
I'm good.
Okay, anybody have questions?
I have a question for Nancy.
Go ahead, Nancy.
If the intervenor status is granted, does the intervenor have the right to cross-examine the petitioner directly?
That would be a question for the LPA to determine, because you don't have, you don't specifically address that in your procedural rules. Bear in mind that my comments at the onset of these public hearings is that fundamental fairness guides these proceedings. Now, perhaps it's not a direct cross-examination, however, they can advise you of concerns that they have, having heard the petitioner, and then you would have the ability to, as you always do, to ask questions during your deliberation.
And
The question though is, can they have questioned the petitioner directly? Obviously, they can present their case and we can, comment and question the petitioner.
I believe that's in your discretion if you want to, having heard some of the arguments, if you want to allow that.
You know, I had this discussion with Nancy yesterday. I do not wish to allow that. I don't want for there to be, I don't want animosity here. This is a decision that we have to make, plain and simple. You
Agreed.
guys have an attorney, do you agree to that? They're just, I don't want this back and forth. Do you agree with that?
No, that was why I asked the question.
Okay.
yeah, my
okay.
question was similar in that could the LPA, if someone is granted intervenor status, could the LPA question the intervenor? Because we
Yes.
don't typically
Yes, you
question
can
a
question the
public
intervener.
comment, right?
Yes, you can question the
And
intervener.
we would welcome it, we would welcome that, absolutely.
Okay,
So, Madam Chair, you've heard the request.
Yep.
You've heard Mr. Davies' objection to it, and it would be appropriate to go ahead and defer and see if Mr. Davies, if you'd like to add anything else for the record.
Sure, thanks Nancy. Noel Davies for the applicant. I actually don't think you can allow them to cross.
We're
even
not
as an
going to.
We're not
intervener.
going to.
Yeah, we're not going to, I just.
And, yeah, again, the objection's noted for the record, but
Okay.
proceed, please, thank you.
thanks, Noel.
So Nancy,
Okay.
then, does the intervenor status, if granted on the criteria which their counsel just represented, that could easily apply to multiple people in the same situation? Residents, neighbors, et cetera. So is it only intervenor status when requested, or if we grant this, it applies to any in similar circumstances here today?
No, it's only who is making the
Very
request.
good, on the record.
Okay. So may I have a motion to accept or deny the request for intervenor status?
I make a motion, oh, go ahead.
I'll make the motion to approve intervenor status for this request, for these.
Do you want to second that, Jim?
Second?
Okay. Is there any discussion on this? Hearing no discussion, may I hear, is everyone in favor?
Aye.
Anybody oppose? Okay. So I am going to limit the intervenor discussion to 5 minutes.
Okay,
Okay.
per party?
Thank you. Per party.
Okay.
Can we treat you as a couple and just give you 5 minutes, or do you want 10? I'm just asking. I'm just telling you, noon, he leaves.
Yeah, I walk
Fine,
out at
fine,
11:55.
honey. No worries. That was just a little levity. All right. Thank you very much. Thank you very much.
And just
All right.
one final question, and
Yes, sir.
with regard to the order, we submitted an order, to the clerk. We would ask that, as far as our, opportunity to speak goes, we allow the experts to come in first, and then.
That's entirely up to you.
Okay, great, thank you so
Entirely up
much.
to you.
I appreciate it.
All right, you're
Thank
welcome.
you.
You're welcome. Thank you all. Okay,
So-
so now I'm gonna ask for ex parte communication.
Well, we still have a couple housekeeping
All right,
items.
Nancy, go ahead.
So we had I believe the experts were identified by name, but I don't recall hearing what their qualifications were and whether there was a
And
vote
Wilson
to
has not
accept.
been qualified, even though
Okay.
he is qualified. Okay, would you two gentlemen come up, please? Would you tell, you have already been qualified previously, but would you give your name for the record?
Max Forgey, F-O-R-G-E-Y, doing business as Forgey Planning LLC,
Cape Coral.
236 Southeast 45th Street, Cape Coral.
Okay. It's been years since I've seen you. This gentleman helped us with our comp plan.
My name is Mohsen Salehi, that's M-O-H-S-E-N, last name Salehi, S-A-L-E-H-I. And I'm gonna date myself here, but I've been around.
Yes, you have.
I've been here since 1990, and first working for Lee County DOT, and then Lee County CRA, when Fort Myers Beach was still a CRA for the county, before the incorporation. And I've been doing consulting since 1997 on traffic issues throughout the state, helping Florida Main Street program, which has very similar problems to Fort Myers Beach in terms of congestion and traffic. And so I've been around.
May I have a motion to accept Mohsen as an expert in his field?
I move.
Second.
Thank you. And is there any discussion on that motion? Hearing none, all in favor?
Aye.
You're officially an expert in Fort Myers Beach. Thank you.
Now
Are
fix
there
the
any
traffic.
other?
Are there anybody else who wish to speak as an expert? Come on up.
Good morning, Matt Simmons, Managing Partner at Maxwell Hendry and Simmons. I have spoken at some point in
You
front of
have, Matt.
council, but
I don't know if we ever accepted you as an expert.
right, that sounds like
Give
solid
us your
judgment.
credentials.
Yeah. So I'm a certified appraiser, licensed broker. I'm the managing partner at Maxwell Hendry and Simmons. We're the oldest and largest valuation services company in Southwest Florida. We touch everything from our day-to-day work is real estate appraisal. We do a lot of work connected, obviously, to FEMA's 50% rule, so we've been knee-deep in all of that for quite some time. What I'm here dealing with today, though, is a type of service we started about, I think, 13 or so years ago, and it's a value impact study to specifically address the issue of potential value impacts as they relate to proposed changes to zoning or comp plan. And so that's the scope of what I'm here for today, and kind of a brief summary of my credentials.
Thank you, Matt.
Thank you.
May I have a motion to
So
accept
moved.
Mr. Simmons?
Second.
Thank you. All in favor?
Aye.
You're official now, Matt.
So we also, I believe, we have staff, Judith Frankel and Jason Smalley, and they've already been
Yes.
accepted as experts. So we have the issue now regarding the agenda. The materials that were included in your agenda, is there a vote maybe to have them accepted into the record?
Yes,
So
ma'am.
moved.
Is there a second for that? This is something we've never done before.
We
Is this
do it
regarding the
sometimes.
documents that
Yes.
have been submitted?
Yes,
Have both sides seen the documents?
I believe so. Mr. Davies, do you want to comment on that? They have been, these are the documents that were provided with the agenda materials.
Yes, we've seen those documents.
What about that box?
We're gonna get to that next.
I just have one comment, and this is nothing personal, Matt and I have been friends for a long time. I do not object to him being qualified as an expert. I think he actually very much is.
He certainly is.
I just wanted to point out one technical point about your rezoning criteria and how that relates to appraisals, valuations, et cetera. So there's nothing in your code that in the specific rezoning criteria that relates to whether a property is going to increase or decrease in value, right?
That's true.
You're all aware of that.
We're all
So,
aware of that.
Yep.
Yes.
for the record, I've got to object to any appraisal, any valuation report coming in, because you're not allowed to consider that, because it's not in your criteria. If you do allow it in, I would just ask that it be accorded the weight that your code allows, which is 0. So, again, noted for the record, and we respect whatever decision you make.
Gosh, we got
Thank
the
you.
A-team in here today. This is gonna be tough. Whew.
But whether the code specifically allows it or not.
Yeah, I would just want to
Okay,
clarify
yeah,
real
go
quick.
ahead.
whether code specifically allows it or not is not exhaustive, doesn't mean it cannot be allowed.
Right.
And just a quick point, there's nothing in the code that says that you have to value it at 0. In fact, I would say the mere fact that you have just voted to accept him as an expert in and of itself suggests that anything that Matt submits to the record has an inherent value as an
Well,
expert.
but, this being a quasi-judicial hearing.
Sure.
We have to only, base our opinion on the information that's brought to us today. And so, but Mr. Davies raises a good issue, a good point, that isn't part of the criteria. I don't know, Nancy, what do you think?
Well, this is the vote that's before you.
Nobody's brought this up before, Noel.
If you want to exclude that from the record, Mr. Davies has voiced his objection. David has said that he wants it in there, and that would be your decision as to whether or not to put that documentation into the record. It has been given to you prior to the hearing because we received it prior to the hearing.
You know, this issue has been raised quite a few times in other hearings. It is important to some members here. Dunlap, you want to discuss this with Noel? Because you asked for this for Neptune. Noel, come back up here. Well, both of you just stand there for a minute.
Exactly, and I think there's a distinction, at least in my mind, the members can do what they do in their own perspective, about what's allowed and what's allowable. And that's a difference to me. And I always struggle with why isn't more information, better context for a better decision. The weighting that you've asked us to apply is completely appropriate because we're not required to give it any weight at all, but it doesn't restrict us from understanding the basis on which it's based, the expert that's representing it, and the criteria they use to get to that point. And I personally like to hear that background information. I just think it gives me context, and there can't be therefore a challenge that there were things that were available to us we didn't look at, consider, et cetera. So that's my point of view.
If I may, so certainly the context, I mean, really it's a relevance objection to not hearing, basically not being prejudiced by stuff that you shouldn't, that doesn't squarely fit
Yep,
within
it's not in the criteria.
the criteria. So, again, this goes back to, Nancy always does the nice introduction about substantial competent evidence, right? And the weight, and, your difficult job in balancing that weight. So you have, approved him as an expert, and to your point, Jim, I think there can be value in additional context, whether it fits the criteria or not. But I just want to give that disclaimer that shouldn't sway a vote, frankly. It shouldn't be a material consideration or really any consideration, because you've got to look at that substantial competent evidence as it relates specifically to your rezoning.
You've done a good job with your client, putting that in context and giving us the
Got it.
guardrails on it.
Got it. Jane, you had a question or
Well,
not?
I just feel that more information is good. It isn't included in our findings and conclusions, so it can't be what makes us find the property or the request valued. So I think in that respect, and since you cannot really value something that hasn't happened yet, because we have no comps against this or for this, it is an opinion, in my opinion.
I would agree. It is an expert opinion. Right.
It's an expert. Anything else, gentlemen?
Nothing for me, thank you.
Gosh, thank you very much.
I think we were just gonna discuss the other documents that
Nancy,
we brought
the
here.
box.
Yes, but hold on, let's go ahead and, if we can, take a vote on the items that have already been provided to you in the agenda, and,
I need a
clerk-
second.
we
Jane
needed
made
a
the motion.
second.
We don't have
Oh,
a
no,
second yet.
one of these guys, I think it was John.
I seconded.
John
You seconded? Okay.
Yep.
Okay, so a vote on accepting the documents that were included in the agenda materials into the record for this proceeding.
So the motion was made to accept them by Jane and seconded by John. All in favor?
Aye.
Anybody opposed? Thank you. Motion carries unanimously.
So, I believe that, Dave, I'm sorry, your last name again is?
Moscoso.
Moscoso, that's nice
Excellent.
Italian, right?
Yeah,
Okay,
exactly.
Moscoso.
Thank you.
I think he has additional documents that he would like to have put into the record. However, Mr. Davies, I need to ask if you have had the opportunity to review these.
If I may just clarify as to the
Okay, go ahead.
contents, because I think that'll help inform Mr. Davies' opinion on the matter. These are physical copies, by and large, physical copies, except for the documents that are on top of the two packets there. These are physical copies of what you were provided, what we submitted to you into the record. And so nothing that is contained in those documents is not something that has been made publicly available for Mr. Davies to review.
So
The,
you wanna look?
absolutely.
The same stuff?
It's the same stuff. The only difference is those maps up top have been updated. There are a few letters in there that were not included by the deadline of Tuesday for inclusion, but there's nothing else. There's no documents that we intend to enter into the record that Mr. Davies or his client have not had a substantial
Can I have a copy of this?
opportunity. Absolutely, you can have a copy of that.
So,
Absolutely.
Counselor, what's your motivation for the additional
Can you not
documents?
say-
Well, we wanted to submit physical
is there other-
copies in
He's got
case
stuff.
anyone here had not had an opportunity to review the documents that have been provided to you. Number one. Number two, we wanted to provide you with an updated map because we do have additional residents who have written letters in opposition, and we wanted to include those letters as well into the record. And so because we weren't able to do that, some of those letters and the updated map by Tuesday, wanted to provide you those new letters and an updated map that kind of reflects what we intend to provide.
I'm glad I slept last night. Okay.
Yeah, thank you.
If it's the
Any
same stuff,
objection, Mr. Davies?
if it's the same stuff, same objections as before, if it's different, I mean, it looks like there's an updated map, like you said. I mean, new opposition letters, I haven't seen those. I'm not
You know
gonna
what?
object to those because you've got the opportunity on public comment, so.
David, is there anything essential that you show us there? Because
The map.
I hate last minute information.
Sure, absolutely.
Hate it.
I know, I totally.
The map.
Yeah,
Okay,
the map
so
is-
could you please just, does anybody object to this, to us only having the map and we can eliminate the box?
Second.
Okay, and what about the letters that weren't entered into the
We
record?
could have the letters also.
Okay, great, thank you.
The map and the letters, the rest of the box you
Sure,
can keep.
absolutely.
I'm sorry for your printing.
No, no,
So-
no problem
It's
at
just
all.
last minute stuff.
I
and-
totally get it, I totally
Okay.
get it, yeah.
So,
absolutely.
Madam
very
Chair, again, just because of fairness and due process concerns, Mr. Davies could get a copy of those letters, and then maybe during rebuttal, he could
That's
make
fine.
any
No, I
comments.
don't, if you got.
Oh, yeah, I'll provide you with a
Okay,
copy,
perfect.
absolutely. Yeah.
Okay, are
Thank
you guys finished now?
Yeah.
Because I am.
Promise.
Thank you very much.
Thank you.
Sit down, David. All right,
So, was there a motion to accept just the map?
just the map and the letters. Jim,
I'll make that, yes.
is there a second?
Second.
Thank you. There's a motion to accept just the letters and the map. All those in favor?
Aye.
Thank you very much. Motion passes unanimously.
So, Madam Chair, one last item, and then I think staff could probably begin. Could you just clarify again for the record the time?
So the interveners will be allotted 5 minutes per intervener.
And we have how many interveners?
We have a couple, so that's 10 right there. And then we have Mr. French. Yes, that's it. And that's right, that's right. So we have 4 interveners,
Okay, so it would be a total of 20 minutes.
20 minutes, yes. Okay?
And the petitioner,
No, I hate.
Oh,
Hey,
All right,
hey,
thank you.
Hey, thank you very much.
Ex
Okay,
parte-
so
wait,
this
ex-
is,
Ex parte.
yes, I know,
Okay.
but,
Gotcha.
Jim, ex parte?
Oh, boy. I've had, obviously, numerous electronic communications, emails, both for and against, the substantial number against. I've done a site visit organized by the residents. Spoke with several of them, saw the property, walked the property, had subsequent conversations initiated by the neighborhood company.
Thank you. Don?
Pretty much the same. Neighborhood company visited the site for the last hearing. Visited the site to meet with the folks in Pelican Watch and some of the property owners. Walked it and again have met with the neighborhood company
Thank you.
and applicants.
How about you, Doug?
I met Ed French and Carolyn McCone at the property and looked things over. But prior to that, I also had a virtual meeting with Ken Gallagher and going over their description of the project in great detail
Thank
with
you,
the
Doug.
neighborhood company.
How about you, Jane?
Yes, I've met with Carolyn McCone and another person, and I did not write down his name, I apologize, and Mr. French at Pelican Watch and walked the property. Also talked with Ken, over the phone.
Thank you. Jim?
Prior to the first hearing, I met with the petitioner and Ken. Since that time, we've received numerous emails, both for and against the project.
Thank you. John?
I also met with the petitioner prior to the first meeting and had a presentation from them. Subsequent, I have met with the Pelican Watch Association, Carolyn, Mr. French, another gentleman as well, and walked the property as well.
Okay. I have spoken extensively with Patrick Vaness about the project, and I have spoken with Carolyn McEwen as kind of the representative of that neighborhood group. And I did, well, I know, historically, I know about this site and this project. Okay.
So having made these disclosures, is there any member of the LPA that believes that they cannot have an open mind and evaluate the criteria based on the documents and the testimony that they're going to hear today?
Anyone? Nope.
And do the attorneys, we have the attorneys for the intervener as well as for the applicant, do you have any questions regarding the ex parte disclosures?
No.
For the record, both attorneys indicated that they don't have any questions about our ex parte.
Any objection?
Okay, or any objection. All right, so the order is gonna be, the staff's gonna give a brief introduction, then the applicant will make their case, the interveners will then speak, and the public, and then the staff will have their rebuttal. And a rebuttal from Mr. Davies.
I think we only accepted
What-
the maps.
Yeah.
What is
They
this?
should not be coming to us.
The letters are in here.
Here, take, okay, yes.
This is what was
Yes.
forwarded to us before, wasn't it?
It
Yeah,
was.
this is already in the record, right?
Yeah.
In the record.
Except
It's
for
in the
the
record.
three
Already
letters.
got all that, yeah.
Okay. Here we go. Judith?
Good morning, Judith Frankel, Principal Planner for the Town of Fort Myers Beach. The application before you now is a request to amend the existing CPD under Resolution 07-28 to provide a master concept plan, schedule of uses, and conditions of operation to allow for the development of a mobile vending food truck park with outdoor seating, consumption on premises, and a commercial shared parking lot. If this request is approved, the previously approved schedule of use and master concept plan under the previous resolution would be invalidated. Just to remind you all, under a separate ordinance, the applicant is also requesting an expansion of that 2007 CPD boundaries to include 2 additional residential properties. That action would increase the CPD boundary area to a total of about 0.69 acres. At our previous meeting, you all voted to recommend approval of that to Town Council. The applicant is requesting 6 deviations from the Land Development Code. I would like you to note that no deviation was requested for the number of parking spaces, as mobile vendor / food truck park is not an identified use in the Land Development Code. However, the applicant used zoning code language of 3 nearby communities to determine appropriate parking numbers. The LPA should consider the code requirements of these communities and determine appropriateness. Staff also advises the LPA to consider the provided recommended conditions of approval listed in the staff report. There are listed extensive conditions which are intended to reduce the potential for nuisance issues on the surrounding community. Also note that the applicant has made a few changes to the proposed schedule of uses and master concept plan since your previous meeting, which they will make note of during their presentation. These include the location and size of the permanent support structure on the site from 1,500 square feet to about 2,500 square feet. Location of the comfort station and the southeast landscaping buffer abutting Pelican Watch has been increased from 5 feet to 7.5 feet.
The conditions governing the project have also been altered in response to some of the comments made at the January LPA. So the applicant is going to cover some of those changes in all of the changes in their presentation. At the end, after you've heard from the applicant and the intervener, I will come back and go over the criteria and staff's recommendation.
Okay.
Okay, do you have any questions? at this
Anybody
time?
have a question for Judith? Thank you very much. Mr. Davies.
Thank you, Madam Chair. I'm back. Morning again, everyone. It's working. Ready when you are. Okay. There we go. Again, for the record, Noel Davies with the law firm of Davies Duke on behalf of the applicant. Our full team is here today. My client representatives are here. James and Debbie Hodka, and also Daniel Myers. Ken Galander and Laura Teft are here from the Neighborhood Company. They are our expert planners. We already went through experts, so you've accepted them as experts. Ken's gonna walk you through the additional changes, so I'm going to be brief and let him do that. And Brandon Fry is also our expert civil, who you've accepted before, so good on housekeeping. One other item, the prior presentation from last month, we'd like incorporated into today's record, as your Madam Clerk usually does. We're not going to repeat that today. We're gonna try to focus on what's changed since then, based on your feedback, based on the neighbor feedback, and my client's discussions with the neighbors, my discussions with the attorney for the neighbors, we've talked a number of times, and the same on the planner side, et cetera. So it is very important to my clients to try to work with the neighbors. They've made a number of reach outs, and you'll hear directly from Dan about the extent of all of that. I know that there were some disheartening comments last time about allegations of deception, which we rebutted appropriately, but I do wanna open that we wanna do what's best for the town, for your island residences, and also work with the neighbors. We're not going to withdraw the project because the neighbor objects, but I think you'll see that there are additional changes that help accommodate a number of their concerns. So Ken will walk you through that. On the legal side, I do want to respectfully remind everyone that we do have significant entitlements on the property today. Things that we can do by right without public hearings, proceeding directly through your DO process. The specifics of that are in the prior CPD, and then there's 2 additional parcels which you unanimously voted to extend the boundary for last time, but those 2 parcels are zoned CB, Commercial Boulevard, and RM, Residential Multifamily. There are 23,000, so if you look at the schedule uses for the CPD, 23,000 square feet of buildings are allowed today. And again, that is a commercial plan development. And you heard me say this earlier, but the importance again of looking specifically at your rezoning criteria and analyzing or including in your deliberations as you analyze whether those criteria have been met, based on the substantial competent evidence. But it's also appropriate and important contextually to compare what is allowed by right today with what the proposal is seeking. And that proposal is specifically narrowed by a carefully tailored master concept plan with a lot of details and even more additions since last time, limiting the property to the specifics on that plan for the family-friendly food truck park use and the parking lot use. You heard from both Ken last time and Judith, and this has not changed, that our proposal today is less intense than those by right entitlements. One additional point as you think about this, I know that the two key words, at least that I've noticed in doing these hearings, and I think is very important in as you're dealing with the very important balance of rebuilding this island, and that is public benefits. My client's willing to provide the public restrooms or comfort stations, and Ken will give you all the specifics about that. Typically, when you're hearing about public benefits, right, it's in exchange for proposing something that's more intense than what the property is entitled by right today. So, give me a little more density, give me a little more square footage, give me a few more units, and I will give the town this basket, this bundle of public benefits, right? And of course, the very challenging job with that is always, is that enough, and does that make sense with respect to the delta of by right entitlements with a proposed more intense or more dense, something that would have more impact from an entitlements perspective. Here, what we're proposing is less than what we can do by right. Still, we want to provide the public benefits, we want to provide specifically the public restrooms, which, as I know you're all aware, has been asked of a number of developers up here and has been refused. But this particular client wants to do that, they want to do what's best for the town and provide that very significant public benefit, even though they're not asking you for more than what they can do by right today. They're asking you for something different, but that different is something less intense than what's by right. And with that, I will turn it over to Ken. I'm happy to answer questions now, but anytime today, we'll probably defer to Ken, and I would reserve rebuttal, as you already noted, Anita.
Absolutely. Any questions for Mr. Davies before Ken starts? Okay, thank you. Can everybody hear in the room? No. It seemed a little low to me. Where's our person back there?
He heard you.
He heard me, okay. It seems, if you could turn the mics up, I would appreciate it. Did you? Okay, well, we don't want squealing, but I want everybody to hear. You don't think the microphone, now it's on.
Hello?
Much better.
Hello?
Hello? Hello, Ken.
What's his other name?
Good morning, good to see everybody. The full component of the LPA, glad you're here. For the record, Ken Galander, Neighborhood Company, on behalf of the applicant. What we're gonna do is, as Mr. Davies mentioned, I'm gonna do my best to go through this presentation. Of course, what we had presented before is applicable, but I think there's a little bit of level of what we need to just clarify and further review what we've changed since our last meeting. But this slide is what we're looking at in terms of the subject property, and it gives you the context of our property in relation to the other commercial and non-residential properties, zoning districts adjacent to us. And I think it's just a good component to see. We are incorporating a RM parcel. It is 0.08 acres of our area. But the majority of our property is adjacent to, over 70% of it is adjacent to commercial and non-residential zoning. We all know where the property is. I don't really want to go into much of the heart of the island and the boulevard and how we're a component of the mixed use in that transitional area. Again, our proximity to the variety of other uses surrounding us, existing and planned commercial. We have a significant amount of residential as well. The town hall, the institutional components, and our beach accesses. Again, our site, one of the main points to clarify is we are looking at that maximum number of food and mobile vending pads to 5. We have come to the understanding that we will be limiting it to that. We are looking at our limiting of our hours of operation. That is staying consistent with the outdoor entertainment. We're going to have the full underground utilities still. Our park support structure, as I'll go through here in a little bit, has been changed a little bit. It's a little bit bigger, as Judith mentioned. Our public comfort station, we have chosen to do a separate structure for that, an accessory structure, complementing the Estero Boulevard with outdoor seating and ensuring that we have the proper pedestrian and vehicular access and of course stormwater. I wanted to provide this slide that gives you an understanding of, we've gone through submitting to the town 4 different variations. That doesn't include what we have done internally. So we've been trying to listen, we've been doing amendments to our plan. Back in May of 2024, we had 6 mobile vending pads. We had a portable restroom facility. We had a storage container. And we know that all changed. We know that the town, we've been evolving since then of what's appropriate and what we can do. We reduced then the number of mobile pads to 5 in the second plan in July. Replaced one of those with a structure for the beverage service. It was going to be a simple structure. Then the plan that you reviewed as part of the hearing last month, we proposed more of a permanent structure that was going to incorporate that beverage service area, restrooms, but maintaining the number of pads and relocating everything basically to that corner that you can see. And then the majority of the rest of the property is the parking. Now, with the master concept plan that we have, that you received in your packet, we have altered the location of where the footprint of the primary structure would be. We have relocated one of the mobile vending pads away from the residential up to Estero Boulevard and basically widened that component along Estero Boulevard. That's where our another outdoor seating area structure that we've added. Before it was potentially going to be a shade structure or some sort of less permanent structure. So with that, I want to kind of delve down into our new master concept plan. Again, that is our the new footprint for our structure. Through that, we've been able to go up in elevation on it. It is 2 stories, consisting of 2,500 square feet approximately. And by doing so, that has enabled us and the client has been able to acquire or is going to bring online the Royal Scoop within the development. So that would be an incorporated walk-up convenient aspect of bringing that kind of iconic business that we know was across the street where Standing Bottoms is. They're not incorporating that in, so we're wanting to bring that into the family-friendly environment there. Additionally, within the structure, we have wanting to allocate area specifically for the music venue, so it would be within that structure, roofed and walled on majority of the sides of it. Through our renderings, you'll be able to see some of these components. Again, what we mentioned before is we've moved one of the mobile vending pads up to Estero Boulevard and expanded that relationship to the Estero Boulevard pathway. Additionally, we added bicycle parking down towards on the southwest end of the project, near to where the beach access is. So we're spreading out the bicycle parking in that component. And then, as mentioned before, with the building and the footprint getting smaller, that enabled us to increase that buffer that is along that eastern property boundary adjacent to the land that's owned by Pelican Watch. And then the last little bit was the component of our comfort station is going to be a separate accessory structure. It'll be designed and architecturally complementary to the rest of the project, which we want to show in our conceptual renderings here. This is a slide that shows us the master concept plan overlaid on an aerial. Obviously, this is an aerial that was prior to Hurricane Ian, but we know that the majority of the improvements surrounding us are staying within those same footprints. What I wanted to do here is to highlight the green space, the open space throughout our buffering, which we believe is substantial. And you can see, it's maybe hard to see, but we are, through our conditions, requesting that we supplement our buffering within the right-of-way, and that would be a component of adding some landscaping and those things. And that's to address some of those concerns about people parking illegally within the rights-of-way adjacent to our property. So this is our updated renderings. Some of the components, this is from a site plan view. What we did is we heard that it's good to try and incorporate our neighboring buildings. So the two buildings towards the top left, those are, one of those homes is under construction and has been permitted. We utilize their plans in our rendering, so that is a accurate representation of their building, and they are elevated. The one that's more just rectangular, that is not permitted as of yet, that we've been able to find in the record, but we have utilized the basic same footprint that it had before, and you'll see by the basic elevation, we understand the need to elevate based on circumstances and FEMA. So you can see here, versus our master concept plan, everything's flipped.
Yeah.
So you have Estero Boulevard on the bottom, Cottage Avenue on the top. You can see the primary structure with the dark roof in the corner, then areas for the seating, and then the food trucks along Estero Boulevard adjacent to the parking lot. And then our other two structures is the outdoor seating adjacent to Estero Boulevard. And then it's kind of hard to see, but the comfort station would be, I don't know how to maybe reference that, this rectangular residential building, it's just to the right of that. Here's from a different angle, looking at the site. This is from Estero Boulevard and Chapel, recognizing we, as mentioned before, we are a major component of this is to vegetate and create really an ambiance of a lush environment, and utilizing that open space and those buffers to complement that. This is a ground view looking at Chapel Street, and what we're representing here is what we are, a component of our conditions is utilizing a portion of the right-of-way, working with the town to appropriately sign and document no parking within this area. You can see the bollards and the rope and the chain component. That is my experiences working in other jurisdictions. That has been utilized to help defray the parking illegally. It is done through a lot of the side areas down in Bonita Springs. So we know it's a effective way to help control that illegal parking. Another view from Chapel, Cottage Avenue. You can see the accessory building, which would be the comfort station. This is a view looking down Cottage. The corner, this view from Estero. This is a view of the structure, and so what we wanted to do, and we knew our aesthetic that we had before was maybe a little bit of a festive and didn't conform with the context of where we are in that heart of the island. In reviewing that, we really ascertained that let's look at doing a different architectural aesthetic for this project. And what we did is it's synonymous to the client's home that they're building, and we felt that that has been recognized as a very pleasing and very aesthetically appropriate home. So let's bring that look to this site and in the context of where we are within the heart of the island. You can see the area where the Royal Scoop or the servicing where the ice cream could be, and then back in the back of the L-shaped building, you have the beverage service, and then in that far right corner would be the location of where the music venue or the outdoor entertainment would be located. This gives a different perspective. You can see the areas for seating, the beverage, and the music venue. This is the comfort station, where we show the two substantial shower components, foot washing area, and it would be servicing both for public needs of those coming and going from the beach, and providing for the appropriate restrooms for the primary use, the food truck park. This is the structure that we're proposing along Estero Boulevard. We want to be able to have the folks eating and enjoying themselves. There's a substantial investment in that Estero Boulevard pathway, so let's engage that with the structure and the elements that we want to have here. Obviously, the bicycle parking and the pedestrian connectivity that we're actually utilizing in this slide as well. They're showing that, and that's that access that is controlled. Those would be removable bollards for the vehicles to come and go, the food truck and trailer vehicles. Just another perspective looking down Estero Boulevard in the food truck park. Sorry about that.
Ken, can you go back to that image? Where's the sidewalk?
So the sidewalk, see where the bicyclist is?
Yeah.
Down at the far end? That's the portion of the sidewalk.
So
it's-
that fence, nothing intrudes on the sidewalk?
Right, we are
Okay.
within our
Okay.
property, yes. Again, sorry,
Touchy.
yes. Hitting on compatibility again, we feel we're consistent with the mixed use existing and envisioned for this part of the island. Again, being the less intense, as Mr. Davies identified, but we're trying to utilize the same development standards that were applicable to the existing CPD. We are, and you'll see through, as I walk through the conditions, our buffering, enhanced landscaping as a component of that, our site design, our orientation of our structures, and the connection to the utility services, no generators, except for, and we just need to clarify, if time of need, if the power goes out or something, they need to have the generator at emergency situations only. Again, our architectural aesthetic, I think we have worked hard to bring that to this more of a, being sensitive to our residential neighbors. And again, our conditions that we are gonna walk through here momentarily.
Just one quick thing on the generator, you indicated emergency only, are you talking about a portable generator then?
The generators are usually an incorporated component of a lot of the food trucks or trailers. So they may have them, but they will have to be required as they are operating on normal conditions, normal circumstances.
The reason I ask is because most of the requirements for those have exercise once a week. They gotta run for 10 or 15 minutes to keep them up to speed, et cetera. And that is, as we've heard from other things in the town, is not a pleasant experience for any neighbor to have.
Okay.
So if you're talking about multiple generators, they're gonna be exercising once a week, I think that has to be.
Yeah, I think we need to provide that as an additional condition or a commitment that we have to appropriately recognize that need. And we just have to better understand the needs of those
Okay.
mobile vendors and whatnot to ensure that that's not a nuisance.
Clearly an open item.
Yep.
Okay.
Transportation, just to reiterate, we've discussed this before, we were granted a waiver. We are, as specifically stated and confirmed by staff, we are in a less intense, not increasing the density and intensity. Our parking has been revised, obviously, because of our structure and what we are proposing in terms of, adding the Royal Scoop, adds square footage, adds a use. So we are now required to provide 30 parking spaces. We are providing 45 parking spaces. We get one vehicle space reduction by providing just 4 parking spaces. So what we have here, and what I wanted to do is, as I did before, I sort of highlighted what was was changed from our prior condition. So I just want to walk through what has been changed from last time. So you had before a portion of the site that was 10 feet in terms of buffer width and 8 trees per 100 linear feet. Now with moving the structure over, we're able to combine that whole thing and provide an overall, and it went down to 5 feet. So now it's all comprehensively 7.5 feet wide along that side. And we have bumped up our number of trees from 8 to 10. Code is 5. So we are providing a significant number above and beyond what code would be requiring. Item 2C, I think it was just an effort in working with staff to better clarify where that buffer is. It was kind of hard to understand, so it's the south and east property lines that are adjacent to these specific properties. And we're providing a 10-foot wide buffer, 6-foot high opaque fence. Why we clarified where applicable, because that fence would connect into the primary structure on the site. So we didn't want to have a structure, a fence right next to that fence. Again, number 3, we are confirming that we're a maximum of 5 mobile vendors and increasing the overall structure to 2,500. Again, part of that 2,500 also is to ensure it's elevated, we have office space for the personnel working on the property, as well as appropriate storage for materials. Number 6, we are eliminating the parking lot being open 24 hours. That has gone away. It will operate and be open consistent with the mobile vending park. Mobile vending, and then the park available from 7 a.m. to 10 p.m. And we are understanding and agreeable that there's no camping or sleeping in your vehicles, no matter what your condition on the property. Again, our outdoor entertainment condition is consistent with what we had before. And what we are wanting to reemphasize is that it oriented away from the surrounding residential properties and toward Estero Boulevard. And I will not be remiss to state again, we are wanting to incorporate that outdoor component within our building. That's not necessarily recognized in this condition, but that is a component that we've been working on in terms of our architectural elements. The comfort station, we had originally mentioned it would be within the park structure, but as we've noted in our revisions, it would be potentially a standalone, closer to the people visiting the beach. And that public access to the comfort station will be the same hours of operation from the mobile, so it won't be deviating, have separate needs than the rest of the park. Number 11, deviation 5, is the ability to utilize that stabilized gravel, lime rock, crushed shell, but we are committed to looking at and encouraged to use asphalt, concrete, or some sort of more stabilized surface. That's just something that we are working on in terms of the economics and the financial aspects of that. Number 17 is adding that clarification, or the town of Fort Myers Beach, Lee County Emergency Management, or the town saying that there's emergency, then we are required to have those vacated. Responsibility then is on the owner of the property to make sure that that is followed, and vendors obviously cannot return until granted the appropriate access by Lee County Sheriff. Access to and from the property, number 23, is only for mobile vendors only. That's that access that I mentioned to you on Estero Boulevard. 24, just further clarifying at the time of development order, the directional and restrictive signage to help manage who's coming and going down Chapel, down Cottage. You know, this is a no-through traffic, dead-end streets. For our access point, right out only, those kind of signage to help people not go down into more of the residential areas. 25 is a little bit more of a substantial condition, and this relates to what I was explaining to you before about being able to make those improvements within the right-of-way and working with the town in terms of buffer landscape plantings, the no parking signs, the infrastructure, decorative posts will be provided to help eliminate the illegally parked vehicles along Chapel and Cottage rights-of-way. The landscaping within that area will vary in width because the road is just varies in terms of its orientation as well. So we will work with a plan and get that approved by the town to ensure that what we are planting and what we are signage-wise is consistent with regulations. And obviously, in terms of that, your vision triangle, those kind of things that we're not impacting. Number 26, I mentioned this before at our last hearing, that we are wanting to be more restrictive in outdoor lighting in terms of falling onto adjacent residential properties. This needed to make sure that the foot candle terminology was appropriately provided. And 27 is an additional condition that the town asked, and we understand this, is that the site is properly managed and maintained. That is an intent of our client. They wanting to operate a very high quality business and entity. We don't want waste on the site. We don't want those kind of nuisances because that affects their business. So we agree with that condition. Again, we are agreeable with the staff report in terms of our consistency with the comprehensive plan and our documentation that we submitted into the record that you all have and that we went over last time at the hearing as part of the record. So lastly, just wanted to hit on these findings and conclusion. Again, our property is significantly, a majority of it is zoned for commercial uses to help implement that boulevard future land use. We are less intense than what can be entitled and developed by right. We want to work with the town. This kind of provides the town the ability to, if they want to, establish firm regulations. No different when the exercise of the town going through short-term rentals. Short-term rentals were coming along. What do we do? What nuisances can we manage and try and reduce? You established regulations, and through that, I think it was conversations through that effort of what are short-term rentals doing in other towns and things like that. So we want to provide, and we are sort of that pilot project for the town. And we believe we have set the bar pretty high in terms of the conditions and requirements. We want to provide a high-quality investment. Again, it's not a carnival on a vacant sand lot. We have really worked hard to develop a master concept plan that's appropriate and appropriately designed to help boost the local economy as it moves forward. The resiliency concept, mentioned it to you before, it provides that area where things can maybe come back. You can utilize this property for, not necessarily maybe food trucks, it could be other emergency personnel, and that property could be used for that. Supporting the town's vision of the heart of the island, utilizing this family-friendly destination. Looking at the commitment of existing vendors, we know that there are about 19 mobile vendors out within Fort Myers Beach and that have received the proper temporary permitting and whatnot, but that potentially can start to go away. And where could they be located to continue their vision to maybe make it into that brick and mortar? And our intent is never to take away from that opportunity for brick and mortars. And we see the success of the food truck entrepreneurs can bring into that brick and mortar. And we feel it's maybe my term, this hybrid of now having that primary structure that has the Royal Scoop in it. Then you have the mobile vending. It's kind of this hybrid complementary even within our property. And it's through that, bringing back that iconic and beloved business, we think it's going to be a benefit to this little part of the island. Again, our revised site layout, we've revised and increased our buffering, we've enhanced our landscaping. We believe our setbacks and our architectural design is now more complementary to the residential area. and readjusting where those mobile vending pads are. Let's bring those up to Estero Boulevard. As we mentioned before, we are hoping to be able to start construction and be open by season. Well, unfortunately, here's another month, but we are still diligently wanting to work with you, work with our neighbors to really get what we believe is a great project heading forward. Based on this, again, our testimony, the competent, substantial evidence submitted, we respectfully request the LPA's recommendation of approval. I know that we have Dan, who's part of the applicant. He would like to say a few words if he may.
Absolutely.
And hopefully I'm still within my 30.
You did great. Thank you, Ken.
Questions?
Oh, sure, sorry
Can you,
about that.
can you go back to the slides where you're identifying what changes or improvements you've made since your first presentation?
With the little circles?
No. The
Okay.
written,
The blue highlight.
That one?
no, the
Oh,
written.
written one.
Yeah.
Let's see.
Keep going,
Keep going.
keep going.
I'm trying. That one?
Nope, keep going, couple more.
I think you
No.
got
I
the
think it's
other
the other
way.
way.
The other way.
Okay. The conditions?
Yeah.
Okay, the conditions.
No.
Not
Well,
that one? There's multiple.
yeah. Well, the 2 points I wanted to make
Okay.
is, one, for access back to the premises, it had town of Fort going to be encouraged to look at impervious blocks to drive on.
Right.
I'll just point, it has no weight.
Understood. Thank you.
Ken, I don't know if this is for you or for Dan, but one of the purposes what we did last meeting was to allow some communication to take place between the two parties.
Yes.
Do you want to describe that, or Stan, describe how you approach that, frequency, the color, the tone and tenor of
Sure.
the interactions with the neighbors?
Sure. So we worked, obviously, to amend our plan, our renderings took some effort to change. I mean, that's not an easy aspect of it. But once we submitted our changes to our master concept plan and our ideas, we then reached out to Randy at Pelican Watch. He was my main contact, and we then worked to find a time that we could all be on a Zoom call with the intervener party, the opposition. Well, that was before we knew that was formally, but we just wanted to have that conversation. We had moments of, we just disagree, but we had a lot of moments of, we understand where you're coming from, what can we do, and we felt that our plan meets that, and we are agreeable to the conditions that we have here, but we're still open to more dialogue on that if necessary.
So does that mean you did or you did not meet?
We did,
You
on
did.
Zoom.
Okay,
Yeah.
okay.
Yep.
Okay.
We did meet on a Zoom call, sorry.
Okay, that's all
I
right.
can tend to be long-winded, like somebody said.
I know. Any other questions for Ken at the moment, Jane?
One question, the restrooms,
Mhm.
it looked like it was not brick and mortar, what is that?
Oh, well, at this point in time, it will be of either stick construction or a concrete block. It's
It is
it's
not going to
paneled.
be a mobile.
No, ma'am, it will be a
It will be
permitted, have to
structurally
get,
sound in the ground and
and
not moving.
meeting all building code requirements, especially for restroom facilities.
Okay, and the second floor of the building
Yes,
doesn't appear to be open in any way or for access for the public, is that correct?
that's correct.
Okay, that's
That would be used for managing the property.
Okay, a condition, I would like to add a condition for the music to be firm inside the building and not just located wherever, because that does protect sound and things like that. So I would like that to be a condition. And, is the Royal Scoop, was that put in also to the hardware store?
That's
That's
Love
Love.
Boat.
Okay, oh, Love, okay, say, thank you.
Mm-hmm.
And,
Not that I go to get ice cream, but.
yeah. Okay, and in the case that the mobile vendors need to be moved, is there any structure in the way of them accessing out easily?
Our design ensures that that area can be cleared out and those vehicles and or trailers can be properly maneuvered out.
Okay, and the building is now a bit of a buffer for the pool and the residents behind, but there will be a high landscaping barrier, correct?
That's correct.
Okay. Okay. That's it for right now for me.
Anybody else, questions for Ken for the moment? Okay, thank you very much.
Can I,
Absolutely.
thank you very much.
Thank you, Ken. Nice to see you again, Dan.
Good morning, Council.
morning.
I'm Dan Myers for the record, and the applicant. And Jane, real quick to address what you said, yes, the music is gonna be contained within the building.
So you don't have a problem having that be a condition?
No, I think we already had that in there. If that
Well,
allows.
it says that it would, it doesn't say confined to.
Okay, so yeah, our vision is that on top of that, it's protecting our equipment, so that all the equipment will be
Right.
undercover, with the music, three-walled with a roof.
Okay.
On top of that, there will be no, music allowed for the mobile vending. They cannot produce their own music, their own sound. All the music will be controlled through our facility.
Very good.
And to piggyback, we're not gonna have music all the time, but with what we're giving, we're trying to limit our conditions of, or what we're allowed to do, so we're kind of doing that. So I'm not an attorney, I'm just a small business owner, so here we go, public speaking, refreshing my speech class from 30 years ago. But my name is Dan Myers. I would be the general manager for this potential business. I appreciate you taking some time to hear me out today. It won't take long. I'd like to focus on 3 key points that I'd like to address. First, I want to give a sense of how we've interacted with our neighbors on this property over the years. My hope is that our actions show a track record of how we run our business and reflect on the character and integrity of which we'll operate this business. In 2016, we purchased 2500 Estero Boulevard. In 2017, after receiving necessary permits, we invested over $30,000 in landscaping and a bollard and rope system around the property to more or less just to make it visually appealing, just to make it a pretty lot. It was a sand lot. We had no intention for building at that point, but we just wanted to, we bought it, let's at least make it look nice. It also deterred illegal parking, and kind of the nuisances that were happening. My brother-in-laws, Jamie and I, dug those holes, planted those trees. I got sucked in coming down on vacation for 3 mornings, no work, and we were trying to beat the heat, so we were up early doing those holes. Later that year, in 2017, we were asked to give up 5 feet of frontage along Estero for the rebuilding of Estero when they were redoing everything. We lost 200 feet of street frontage, 5-foot depth, which is about 1,000 square feet of land, and that's about $190,000 in today's valuation. But we agreed without hesitation. Fast forward to 2023, the Whiteheads, the neighbors directly behind us with the old schoolhouse, directly behind 2518 Estero Boulevard, they approached us for a reduced setback, to reduce it from 10 feet to 5 feet, so that they could build the home that they wanted to build. Without hesitation, we agreed. In July of 2023, Beach Talk Radio ran a story on this project when it first came online and we approached the town. While most of the comments, a majority of them were positive, I understand it's not, located in close proximity to the neighbors. One concerned neighbor, Mrs. Danford, did raise in the comment section she had concern. So I took the initial approach to find her email, reach out to her, and tell her about our project and kind of lay it down in detail. Over the next year, the Danfords and I did keep an open line of communication. We exchanged updates on each other's progress through permitting and what we were doing. On December 20th of 2024, about 8 weeks ago, I was contacted again by the Danfords and asking if they could use a portion of our lot to help ease the construction congestion that they're experiencing, which is going to be everywhere I think for the foreseeable future. But we said not a problem at all. Even 2 weeks later, receiving some legal letters, I didn't call them up and say, stop it, you know, that they need this. It's do it, use it, and still to this day, I'm okay with them using the lot. We do need to work together so the island can kind of build back better. After Hurricane Ian, we worked with the town at 2500 and assisted or allowed the town the use of the lot for cleanup effort. Once the town was done using the lot, within 3 months, we had cleaned it up, we graded it, and we had added the sand back to it. So we kind of restored it to at least something presentable until Milton and other things came through and washed off that progress. In my opinion, until recently, we always had very positive interactions with our neighbors. I'm sorry that we're kind of coming to this legal issue, but I'm a very non-confrontational person. I've always operated my businesses with my customer satisfaction coming first. I always tell a new business owner, if you do what you say you're gonna do, you will be successful. If you commit to a time, be there. If you commit to a price, honor that price. You may take a loss, but you will learn.
That's so true.
Gaining a relationship will pay off more than getting a quick sale. And that just shows over time. And I think we have 7 years owning this property where we've tried, we've at least tried. We may not have agreed, but we've tried. Your character is what you do when no one's watching. It's truly who you are. We've always loved Fort Myers Beach for what it was, and we hope to be a part of the new fabric of Fort Myers Beach that's emerging. The resilience of the residents and the businesses are inspiring. Many cities that experience this devastation don't return. So while however difficult this process is, and I commend you all for what you do, I'm on one project. I can't imagine the burden and the stress and the level that you feel daily. So thank you for your civil service. But I'm happy that people are at least trying to build back. That's inspiring. Last 2 paragraphs, I promise. The second point I want to cover is our evolution of this concept and how we arrived at the plan today. I first put pen to paper on this project in March of 2023. It was 6 months after the storm. There was rubble, but it was more organized piles of rubble at that point, scattered around. The entire town was kind of in an unknown midst of what's happening. Food trucks did become the saving grace for food service on the island as we were rebuilding. I also knew that food trucks would soon face a challenge of competing with land development and reconstruction. And my thought at that time, this was 6 months post-storm, it wasn't with FEMA regulation and what's gonna be allowed, it was with my vision for doing this project back then, or trying to envision it, was you're not gonna be able to serve a cheeseburger, we're gonna build a 4-story building. I saw that happening, not with all the other stuff happening with, the FEMA going on right now. But the growing trend of food truck parks, I wanted to create a space for businesses that came to the town's aid during Fort Myers Beach's darkest hour. By 2023, by May of 2023, we had our first rendering, and by July of 2023, we had reached out to the town to explore the possibility of moving forward with this project. Over the next 18 months, we worked to create a CPD that takes thousands of hours and thousands of dollars just to be able to have the privilege to stand up here and present what we've done. I know it's being called a food truck park, and I want to put more of an emphasis on the fact that the food truck park is only going to be about 20% of our return. I get it's the main component of the focus, but the project as a whole is the business. So with the new structure, which we really listened to, what is this going to be 10 years? How will this fit into the new Fort Myers Beach a decade from now? The structure gives us options. It gives us more of a potential for the future. And the fact that while it is being called the food truck park, that is not, they're clients of the business. That's not necessarily the business itself. So I just want to make an emphasis and point on that. I think that should carry some weight. But I can ramble on, but I'm going to stop right now. Does anybody have any questions?
Oh, Dan, you're charming.
Thank you so much.
You're welcome. Any questions? No. Thank you very much. Wait.
Mr. Hopkins would like to say a few words.
Absolutely.
Thank you.
I'd like to tell Jamie that I love the addition of the navy blue on your house. Looks fabulous. Good morning, Jamie.
For the record, I'm James Hutka, and I have been sworn in, so I just have a couple of statements to make, and I don't know, this has been a frustrating experience and,
Sure it
for
has.
everybody.
Will you
And,
pull that microphone down a little bit for you? There you go.
Yeah. Basically, this is a family food truck park is what we're asking for, and I sat at that address at 2518 for over 10 years and just watched people walk down the street. I mean, just groves of people walking back and forth, and you don't see that anymore. There's nothing south of Diamond Head. And there will be people walking again, but we need these businesses up and down the boulevard. We do. And I think the town's even acknowledged that. Now, this is a little bit different. This is out of the norm. And I think that food truck parks are becoming more popular. I know there's nothing in your ordinance to allow that. And I think you're dealing with a company that's going to put the people in the town first. So we're willing to float with whatever needs to happen to get this done, but I do think it's necessary. I think that this is a very important, very, very important project. I think what's happening here is a lot of fear, the fear of what's gonna happen or what it's gonna be. And I bought this lot because I didn't want noise and I didn't want the beep, beep, beep from Estero. And so I truly understand what the neighbors don't want. And we're gonna try and mitigate that as best we can. I also know that living on the beach, that you're gonna have people walking through your yards, like it or not. We've had people use our showers. We're trying to mitigate that. We're building a building that blocks the last two houses where they can't go that way. We're trying to create a landscape buffer that forces people to the beach access. In the bay, it's necessary to have people use the beach. And this is an enhanced beach access. I think that there's nothing like that on Fort Myers Beach. And I think that we're giving a lot more than we need to, but it's what I would want if I lived there or if I visited there. And that's where we're going. Mistruths. I think it's 80 or 90% zoned for business. And I don't know zoning laws, but it has the CPD and it has, I don't know, the 2518 has a business zoning and just that little residential property that we're only gonna put a few cars on. So it's not like we're asking to change a big residential lot to commercial. We're asking to include one of the residential lots in this project. More traffic on Estero, and I don't see that. I see the people coming back to walking. I see people parking there all day and using the facilities. I think it's less traffic it'll create, because right now that there's no place to walk to. We need that. And also, I see that, once again, these food trucks that are on these vacant sand lots, once they start to build, they'll get thrown off, and there's no place for these businesses to go. And I'm hoping to provide a spot for that. Out-of-town investors is one of the big worries. Empire Holding Corporation. Well, I created that years ago for my children, because I was told by tax planners I needed to put things in a trust. Ann Trust is named after my wife and her middle name. We are local, and we will try and work with the town to help them better define what's legal for here. But right now, we put up a $5 million lot. We're building a $2 million building. And, if they incorporate some of that in the new food truck thing, where you can't just put a food truck on a sand lot, I understand that this has completely changed the dynamic of what we're building. And, I hope that continuances have just killed us. I mean, I don't even know what we'll make next season. And I'm really worried about that, because that's part of our business plan to be open next season. The needs for Fort Myers, obviously the restrooms, the comfort stations, the showers, the water bottle fill stations. I know when I ride my bike, it'd be nice to get a water somewhere, refill my water bottle. And I just thought, we want to do this because I see there's a need. I drive up and down and not so obvious needs. Well, quick development. I mean, we need something developed on this island. My wife and I eat out every meal, and you're running out of options. And, we're leaving the island, so we're driving places, so we can't take our bikes to where we want to go. So this thing will be up and running hopefully next season. And the rapid restoration of food services, God forbid if another disaster happens on this island, we can be up and running and provide food to people. So I think all of these things are benefits to the community. And we have listened. I mean, we try to listen. Every email we took seriously. We tried to make changes to stop it. We tried to block the music. I don't even know if we'll need music. I just want to have it.
Can I ask you a question about music?
Yes.
it's one of the biggest complaints is this live music and sound. And, you know, if you go to Coconut Point Mall, you hear music everywhere you walk, but it's ambient music. You hear it because they've got their speakers. They do a beautiful job of it. So would you agree to having, Dan just said that you're gonna control the music inside that building?
Yeah.
So would you agree to no live music and you all controlling what people are hearing from that building?
I don't want to speak for Dan. As I said, this is his project.
Well, it just occurred to me now, otherwise I
yeah.
would have asked Dan.
You could
All right,
put,
so
you
you
could
think
put
about
Dan
that,
in that
Dan.
spot. I don't know. What we're trying to do is put butts in the seats, if you want to use
Yeah,
that word.
I get it.
I don't know what that's going to take. If I don't need music, I won't have music. Ambient music's nice, but once again, I can't answer that question.
Well, by ambient, I'm saying
I know what you-
completely controlled by,
Elevator music,
by you.
yeah.
Well, not even elevator, but not live music.
Well, it would be through our amplification. I mean, that's fine. They don't have to have the giant speakers and the boom, 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 but we could do it through our amplifiers. Yes, we could. I'm sure that Dan would agree. I don't want to agree to something like that. I don't know the business.
Just throwing
behind
it
Yeah.
out there, because it
Okay.
just occurred to me.
And I think, didn't we talk about last time?
A little bit. Touched on
A
it.
guy or girl with a guitar
Right.
or a
Yeah,
keyboard
that was
is
on there.
very,
It's not a band.
Only solo
not
or
a band,
dual.
right,
Right.
right. So we already, I think they already agreed to that limitation on live, but.
But on top of that, we could control that, we are in charge of controlling the solo duo acts music. So they
Yes,
don't
but
have
Dan,
control.
that's part of our
Yeah.
noise ordinance. And all the restaurants are supposed to do that, but we still know that the sound is obtrusive to anybody who is adjacent to that, if they don't like it, you know, so, yeah.
I think if that's the key factor, we can find a way, whether we're doing tiny speakers on tables or however, there's gonna be a way to mitigate that. I mean, there's systems out there, there's ways out there, so I'd be more than
Certainly.
happy if that's the main focus of this, then yes, we can figure out music. Am I gonna, yeah.
You know,
I think it's
a follow-up to that would be, I think when you stated earlier, you're not sure how often or when you're going to do music. If you restricted it to certain days, because right now, it could be 7 days a week, but maybe if it's weekends only, it's different than if it's every day.
I'm not opposed to that. Where it gets finicky and squishy there is the fact that, you know, 4th of July doesn't always fall on a Friday, or St. Patrick's Day.
Well,
isn't
you can
on a
always add holidays.
Yeah, well,
too.
there's the special events. We maximize our special events to a maximum of 15, and that's incorporating Songwriters Fest, Shrimp Fest, Boat Parade, Super Bowl, college championships. So I think that's where we came up with our 15 number for special events. More or less tailoring to the kind of what the town's doing. But no, this is not a nightly music operation. So maybe we do a condition of no more than twice a week or 6 times a month outside of the
Well, that would,
special event.
that would
character.
tend to mitigate some of the noise concerns.
Yeah.
If they knew that, if the neighborhood knew that it was only occasional instead of potentially every night.
Okay, yeah, every night's not the vision, and I'm more than happy to delve into this over the next 2 or 3 weeks, before council to figure that out or learn more about that.
Thank you. Okay.
One last thing, this thing has been delayed, and I respectfully ask that you either, turn us down or approve us.
Oh,
and-
we
and
will,
move us
Jamie.
on.
It'll-
Even if-
it'll
even if we
get- it'll
tie.
get resolved
Even if we
today.
tied, send
I
us on.
understand. I
This thing
understand.
is somewhere between $50,000 and $100,000
As long as
per
Brian
month
doesn't
of season
leave.
weather. So,
Right.
All right.
once again, between $50,000 and $100,000 per month in the season months, and
We
if we miss
understand.
next season, it's
We understand.
devastating. So thank you
Yes.
for your time.
Thank you very much. Okay, now, Noel, did you have something to follow up with? Nothing further. Okay, so I am going to now open the, public, or Judith, do you have anything? Or do you wanna wait?
I think you were gonna do the intervener
Yes, the
and then
interveners
staff.
are, yeah,
Okay.
okay, interveners. Can we come up with another name for that? It sounds like little
Agreed
troll
parties.
people running around.
Agreed to party.
Oh, okay, well, that sounds like they're gonna be mad, no. I'm gonna come up with something better,
Sure.
okay, go ahead.
If I may, our preferred order to present has our experts.
Hold on one second.
Of course.
Doug, are you asking for a quick
He's
break?
gonna go get some.
Okay,
Sure.
before we move, we're just gonna take a quick break.
Thank you so much.
All right, thank you. Gosh, is anybody else cold in here? I am freezing.
a little bit, yeah.
That's why I always wear these long sleeves.
Madam Chair,
Nancy?
I understand that we will be losing, one of
One
our
or two.
members.
Yes.
So at this point, maybe it might be, a good opportunity to go ahead and plan so that maybe we could try to facilitate getting a decision today.
Yes.
So I understand that we're gonna lose, Don at 12, and, somebody else too, Doug?
Doug has to.
I have something at 2, but I'm sending an email to change it to 4 o'clock, so.
And
yeah,
Don,
so I
you
don't
think
have to.
that you could maybe push it till 12:30?
I could maybe push it to 12:30, but
I don't
not
think it's
so.
still gonna
No.
matter.
Well, let's,
Right.
12:30.
Absolutely, I can
Okay.
make that time
Thank you
frame
very
work.
much.
We have made significant changes to how we're gonna proceed in order to make that time accommodation work. So, in terms of the order that we'd like to engage in, we wanna have our experts come in first, just so that the board has the benefit of hearing those opinions. After each expert has presented, we're gonna have our aggrieved parties, and that's gonna be Randy, that's
better.
Randy, Bryce F., Tom, and Deb Danford, and then Ed French, and then I'm just gonna come in and just provide some closing remarks, and that'll be it, and I think we'll.
And so
we'll
we're
make
not
that.
having any public comment?
I think most of
Or
our
everybody
Pelican
has
Watch
agreed?
folks have agreed to cede their
Okay.
time, in the interest of arriving at a vote.
Wonderful.
In the interest of the board members. Okay, so, excellent. So if I may, then I'll just
Yes,
introduce
please.
Mohsen, our first expert, and then they'll follow.
Thank you.
Mohsen Salehi for the record, Mohsen Salehi. As I was briefly discussing that with then Mayor Saracita, this comp plan that you have is really and truly a labor of love. A lot of dedicated people contributed to that just to maintain the quality of life for Fort Myers Beach. And the idea was that we're gonna look at Estero Boulevard as a litmus test to judge and to evaluate and gauge really the impact of developments, small or large, and realize recognition of the fact that if it helps Estero Boulevard and lessen the congestion on Estero Boulevard, it's good for the community as a whole. Now, for concurrency purposes, Estero Boulevard has been divided into 4 segments, from Big Carlos Pass to Voorhees, from Voorhees to Tropical Shores, and from Tropical Shores to Center Street. The segment that has been consistently failing, even way back when I was working for the county and before the incorporation. And like I was telling Anita earlier, that, you know, the logic of, you know, since this is a constrained facility, Estero, and this particular segment from Tropical Shores to Center Street has been showing level of service F, which is failure, we should dump more and more traffic on it. And this is where, you know, every effort should be taken to lessen the impact of any development, large or small, on Estero Boulevard. And frankly, having done development review for the city of Bonita Springs for a number of years, close to 10 years, I can tell you that during the methodology meeting that you have with applicant, in this case, in my case, on behalf of the city of Bonita Springs, we were putting everything on the table, all the requirement, what needs to be done to, first of all, put everybody's mind at ease that the impact of this development is fully, first of all, fully accounted for, and second of all, what is employed to mitigate that. Now bear in mind, having worked on, traffic issues for a number of years, we've noticed in Fort Myers Beach particularly, that you have a different environment when it comes to traffic. Normally, in most arterials, you have a peak and valley, and then again in the PM, another peak and valley. In Fort Myers Beach, what we have is a plateau. In other words, you get to a point where the traffic has been saturated. Volume to capacity is E, and even worse, F. But then the cascading effect keeps the traffic going. So this is why you have, Estero Boulevard that is assumed that it's constrained because it reaches its full capacity and beyond, but still it just drags on. I mean, it just, like I said, cascading effect moves the delay further and further. But I don't know if some of you may remember Petro, who used to run the Chamber of Commerce. He used to run this survey every year, asking folks who are visiting Fort Myers Beach, would you be coming back given the congestion that we have here? And then they were saying that, no, this is my last time. And then they were taking the same survey the following year. Why? Because it's a people's beach. It has this attraction. A lot of people come in. As part of the comp plan, as I was discussing that briefly with, former Mayor Sarcita earlier, this was a labor of love because everybody really wanted to keep things in a manageable way, even congestion. That's a reality. Congestion is not something unique to Fort Myers Beach. We have them all over the state, all over in every major city. You have that issue. But in here, what we have is something that, needs to be taken care of incrementally. Like, in the comp plan, we talked about this idea of interceptor parking lots to keep folks from, to give them an option that you can park here and get a free trolley and go anywhere in the island. And especially for tourists whose time is more spent liberally than, folks that, have to make a living during the day. It's something that, makes a lot of sense. And we felt that technically this should be taken into account. To give you an example, being after these general comments, to be more specific, the operation of this proposed food truck park for Estero access, being from 11 a.m. to 4 p.m., coincide with the meaty part of that plateau I was talking about. And this is the impact. I mean, despite the fact that we have a paved median right now, and that should help when it comes to turn movements to a certain extent, but without having a traffic impact study that shows full impact of this development, not only on Estero, but on Chapel Street, and by extension, even Mango, when it comes to turn movement. I can tell you this, as a personal experience, we were involved in this coordinated signal system for US 41 back in the 90s. The idea was that whoever follows the speed limit and goes by the rules is going to be rewarded with this green light after green light after green light. But in all these years I've been here, I've experienced that personally myself, maybe a handful of times. Why? Because human factor is something that throws everything out. In terms of, models, traffic models are for rational behavior. But then, when it comes to individual behavior, this is something that, we make shortcuts, we do this, we do that, anything to, make our trips shorter, even if it's at the expense of others or the facility as a whole. So, my point in the, in my report, which I trust you have had a chance to look at, is that there's really no issue with food truck parks in general, in and of themselves. But the location at this level of service F, at this particular segment from Tropical Shores to Senator Street, is what questionable. I mean, I'm sure further down, segment from Tropical Shores to Voorhees, and then from Voorhees to Pescadora, from Pescadora to Big Carlos Pass. The last segment is actually experiencing a level of service A, which means free flow. No problem there. Well, the other two segments right now is level of service D, which means it's functioning, you still have capacity, and obviously the paved median has helped quite a bit. Well, like I said, when it comes to, parking, for example, you can do all you want on Chapel Street along the property line for the proposed development. But ultimately, anybody who can't find a parking spot there is gonna go elsewhere. I mean, this can be the circle, the area of influence for this can be anywhere from, like I said, I don't wanna prophesize here, but without a traffic impact study that fully takes into account all of these factors, all of them, you don't know what you're dealing with. I mean, saying so doesn't make it so. Saying that the approved ordinance from 2007 would have had more impact without showing, why do you say that? Show me the numbers. And this may be the case, but nonetheless, without, something on the paper, without realizing the assumption, like I was telling you before, a methodology meeting is a must between the applicant and the town staff to go over all these concerns, including specifically the concern that we all have for Estero Boulevard being the litmus test for quality of life for the entire island. And this is where, this was one major area. The other one was the fact that the objectives in the comp plan, particularly objective policy 7 and objectives and policies that follow, most of them put Estero Boulevard on top in terms of, this is once again the maker or breaker. And any development, large or small, can be that proverbial straw that breaks the camel's back. And do we really want to wait until we get to a point where, traffic is so horrendous on Estero Boulevard that even right now the plateau that takes place anywhere from 10 a.m. to 6 p.m., an 8-hour span, this is gonna expand to hours that, we never thought that you could have a traffic issue at 8 in the morning, or 9 in the morning, or 7, or 8, or what have you. And these are things that we have to have this long-range look at impact of all developments, large or small. I mean, this issue came up with Margaritaville. That they said all the right things, anything from you're gonna have interceptor parking lot, improve on that, and help people have an alternative to get to Fort Myers Beach. But the jury is still out, because we've had this misfortune of having to deal with back-to-back hurricanes. As a matter of fact, the only permanent count station that we have in the island, which is about 100 feet or so north of fire station, that's where, you know, you counting on, you know, trends, traffic trends based on historical data. But, you know, that permanent count station is out of operation, and the only counting traffic that we do right now is probably either quarterly or spot, depending on, you know, whether the development, the developer wants to do it or not. Or if they're required to do it or not. This is most importantly, you know, the point here.
Motion, let me see if there's any questions for you. Does anybody have any questions right now?
Yes.
Go ahead, Jim.
The property owner, by right, could build a building, and he's proposing a food truck park. Does the food truck park generate any more or less traffic than what he could do by right?
This is exactly my point, that we don't know because the study wasn't done to show the full impact of this development. Not only on the, I mean, this is where the methodology meeting with staff comes in. That you sit around the table and put all the regs on the table, that, you know, this is what's required of you. You have to do a traffic impact, and then area of influence for this development is a mile around the development, or what have you. And then on that basis, you can see whether you need a storage lane for turn movements, whether what's on the Estero Boulevard, the pavement, is sufficient, because queuing study is, you know, when you see how traffic backs up. And without, you know, doing some sort of simulation of sorts, anything that studies, once again, the full impact of this development, all the turn movements, all the possible turn movements, and how the immediate block or the blocks on either side, which is inevitably going to experience spillover, you know. This is where you're gonna have to really think outside the box and start thinking that, you know, what can we do to mitigate or minimize this? Like I said, frankly, if it was up to me, I would have found this application insufficient for review. And once it has a decent TIS that looks at all the implications of this development on all the roadway system, starting with Estero, and even, like I said, not only Chapel, but even as far north as Mango, and see what can be done to mitigate the impact on all these roads and traffic. And when it comes to parking, I know a thing or two about parking. I know that when you're looking for a parking, if you couldn't find it in point A, you go to point B. If not in point B, you go to point C. And, you know, this is where, like I said, you can do all you want to Chapel Street or around the perimeter of the proposed development to stop people from parking there. But that doesn't stop them from parking on, you know, Pelican,
Of course, of
yeah.
course. Okay, hold on. Jim, your question?
So, two of them. So is your testimony today, we don't know?
Exactly.
Okay,
I don't
that's
know.
good.
That's it.
And
Yeah.
then secondly, so based on your experience, if they proposed a parking lot for the entire property, just not 2/3 of it, would you have the same concerns about aggregation and concentration of traffic getting in and out of the parking lot?
Like I said, I still like to see, because I don't wanna,
But you've got
Prejudge.
experience. I'm trying to kind of go where Jim was going.
well, well, you know.
What
that-
is the draw and what's the concern?
Well,
If the
that-
draw is the food trucks are causing additional parking or additional challenges, or if it was a parking lot, would be the same thing, there just happen to be food trucks there. I'm just trying to discern where the concern is about the development itself, whether it's nothing there, parking lot there, or doesn't matter, and we don't know.
Jim, I believe his concern is that there's not a traffic study, period.
Yeah.
The concern is that there's not a traffic study. And David, may I ask you, is that the reason that you have motion here to say we need a traffic study for this?
Absolutely.
Because
And we got
that's,
to the point.
in the interest of time,
There you go.
you've made that point, motion. So I'm gonna say thank you very much, and let's
Yes.
get our next expert up here.
Yes,
Thank
thank
you.
you.
You did a good job. All right, so we needed a traffic study.
Can I ask a question?
All right, yes.
When when a CPD is initially issued, there's a traffic study, correct?
Not necessarily.
No?
There should be.
Okay. So I mean, we don't know if the CPD that was initially granted had a traffic study or not for the building and parking lot
It
that
wouldn't
was
be
there.
one that didn't work.
It would be one that would be in the files, and I don't know if you all found one.
I didn't want to cut him off, but
Yeah.
I just, he's
Understand-
here to
yeah.
testify, there's
Right.
no traffic
Yeah.
study.
Right.
We got it.
Yeah, we got
Okay.
it, yep.
Uh,
Did staff,
Yes, yes.
was there a traffic study with the CPD originally or no? Okay, okay.
Matt?
Wonderful. Again, Matt Simmons for the record. I heard the sage advice earlier that less is more, and so in the interest of time.
Thank you, Matt.
Yes, I'm also going to try to be brief, but cover the important elements of what we did. Again, I mentioned previously, value impact study is what we did here. It's leveraging what we do as appraisers, brokers, valuation experts on an individual property level on a day-to-day basis, making, say, adjustments in a sales comparison process for a better view or a worse view or a better location or a worse location as measured by how the market prices each of those properties. So it's just taking that skill and applying it to a specific set of circumstances to try to isolate, okay, what can reasonably be anticipated as it relates to impacts associated with this just isolated use. So, in brief, my professional opinion is that the approval of this project will have a negative influence on the surrounding residential properties that are close by. I think what that comes down to, when we're talking about Pelican Watch, I've formed a specific opinion as it relates in aggregate to that building, and it's roughly 8 to 10% is the reasonable anticipation of value diminution that would be applicable across. They've got 48 units there. Obviously, the units that are most influenced would have a heavier price influence. The ones that are furthest away, would be on the low side. So that's in aggregate. The 8 stack of that building is the stack that has the worst exposure as it relates to the proposed project. So that's the specific stack within the building where I would expect to see the most value influence. The directly adjacent single family, I believe the value influence is likely to be in excess of 10% though. And I don't want to oversell what can be done with the data when looking at this specific situation. So I'll say that you could justify, I think, from the analysis we did, diminution in value on the low side for single family, 10 to the high side up to potentially as much as 30%. Again, not all single family properties, 2563 Cottage is already under construction. It is directly adjacent. Just about go ahead and grab a drink from your backyard, literally. That close. That building is already on the second floor of construction. That's going to have a significant, value influence as it relates to that property. When we're trying to talk about the specific uses that are concerning, we're talking about noise pollution primarily, a activity that is based on outdoor consumption, food and beverage, the food trucks, sights, smells. In some ways, I appreciate what the applicant has put forward, and I can see some of the things that are being revealed today, that they're trying to mitigate some of these things. That is difficult to do with a food truck park. I understand that. I like food truck parks as an asset. I have invested in a food truck, not on or near Fort Myers Beach, but in a concept. I get this. I think it's awesome and would be great for Fort Myers Beach. It is just one of the most difficult things to locate in a way that it does not have a negative value influence. The other example of that is industrial. Industrial versus residential is oil and water. And so some of the ways that you would potentially mitigate that, it's like, there's only so much you can do. You've got live music. I saw the rendering of the building today, and I know we were talking about an enclosed building, but where the music is taking place, at least two sides of where that was happening are open. So, the enclosed part, I'm not sure that, you know, that captures the concern as it relates to noise. I want to briefly mention methodology. Oftentimes what we do for value impact studies is we're grabbing individual sales data points that where the only variable involved is whatever we're trying to measure, a single sale versus another single sale, and we're, you know, taking an inference as it relates to the price difference. We also do that same exercise in aggregate with larger data sets that collectively can answer that question. That's extremely difficult to do on this project, simply because I can't find an example of one. I'm not saying there isn't one, but I cannot find a food truck park this directly adjacent to residential uses. Single family is obviously closest to it, but the height of Pelican Watch and the noise amplification that takes place, particularly for units that have direct exposure, I'm really concerned with that aspect. And so in the absence of specific food truck park examples that I can pull and look at, we look at other external negative influences like noise or other studies where we have isolated a negative externality and can kind of impute that onto this situation. The one example though where I was able to at least leverage a peer-reviewed study that was completed, it's in Portland, Oregon. It's a study completed in 2017, exceptionally well done, exceptionally detailed. What I'll say is the conclusions that I'm offering in my expert report and that I've shared with you here are entirely consistent with the results of that study. I went through that study in detail because it's the only study that, at least that I was able to locate, that was specifically on the residential value impact associated with food truck parks specifically. And if you kind of overlay the takeaways from that study, again, that's directly consistent with what I'm representing here today. The only difference I'll say is that food truck park actually didn't have a live entertainment component. So it was just a food truck park element. So I think if anything, what we're looking at here potentially has the ability to extend beyond that. And the last thing I'll say is that the influence is not just as it relates to properties that are already built. As has been talked about today, there's vacant land that's still surrounding this, obviously a result of what we all went through 2.5 years ago. And so I want to be clear, it's not as if the loss in value only happens once a home is built. The highest impact to a value loss would actually be at the vacant land stage. Because let's say the property next to 2563, which is the one that's being built, I think it's 2553. Let's say that site were to go on the market and this project were approved. If I were to then go build a home on that site, I know what my cost factor is going to be to build, okay? And I can interpret from sales data what I think I'll get from that, considering the food truck park element. So the only component of the cost that I have to be able to mitigate a negative value influence is associated with the land component. Land is always the most volatile aspect in any market, up or down. And so I just wanted to at least mention that we're talking a lot about improved properties, but the value influences are beyond just improved properties. They actually are even more dramatic as it relates to vacant, residentially intended land. And so with that, I'll wrap up my comments. I'm happy to answer any questions.
Questions for Mr. Simmons?
Only one quick one perhaps. Did any of your data points include designating this as some sort of an amenity that someone would want to be around? To go back to Anita's point about Coconut Point Mall, they build residences above the entire place, and that's an on-purpose buyer. I get all that, but there's a valuation with having access to and being close to. So did you include any of those in your analysis?
That's a great point. There are studies that are out there that identify that parks, sporting venues, amphitheaters have a positive value influence. I would, however, highlight those studies all make a point of identifying that positive, broader community sense is outside of the immediate vicinity. Every study that I've seen that rightly underlines that takeaway, which I agree with entirely, makes a point to say that's applicable to the community more broadly. That is not what happens necessarily directly adjacent to the use.
Did you look at any of the properties that are located down Crescent that are affected by the Margarita Pool and open decks and things like that, and the traffic there with walking?
I was trying to get as close to a food truck park as
You
possible.
to make a comparison, is
Yeah.
what you're
In
saying.
Right.
comparison to the open pool,
Or
music,
noise.
and everything
Noise,
else,
yeah.
yeah. both.
So-
Outdoor activities.
Same.
So, yeah, two things I would say, yes, from noise and some of the other influences, I think, yeah, there's a reasonable connection you could make. Food truck park, again, you're dealing with noise and you're dealing with smell, you're dealing with outside consumption. It's a little bit difficult potentially to capture all that, but the biggest difference I would say is anybody in and around down Crescent Street, you're in the downtown core. You know where you are.
That's right.
To me, the comp plan is crystal clear as it relates to the vision that's cast for these distinguished areas. That's, I think, part of the underlying concern is, yeah, this sounds great for downtown, but it seems to me as if I were a purchaser in the land use designation that we're dealing with here, I would not be anticipating necessarily that kind of a use in that spot.
Quick question, is it your opinion that, so if it weren't a food truck park, if it were a restaurant or a closed stall kind of thing, like there's one in Benita where it's kind of a, think of a mall food court for lack of a better, is that a different view than a open air food truck? I mean, because the food trucks are trailers, right, and otherwise you're under a roof, is that a difference in the?
Yeah, hypothetically, if it was enclosed in a restaurant, yeah, that, I mean, and there's a CPD zoning on the property. Any
Right.
reasonable buyer there would understand what's in place and would anticipate, hey, it's not as if I get open park space. I certainly don't want to suggest that. There's a CPD zoning in place.
Right.
That's right.
Commercial uses, to a certain extent, are entirely reasonably anticipated, if not just outright expected.
Right,
So.
yeah, there were restaurants there before.
There were.
Exactly.
So,
To that point, what I've tried to offer is specifically my opinion as it relates to the food truck park component, weighing qualitative factors such as that, because I couldn't
Yeah.
agree more.
thank you.
Thank you very much, Matt.
Thank you.
Appreciate you being here.
Thank you very much.
Yes, sir. You're right, we won't make it too
Good
long.
morning, Max Forgy, member in good standing of the American Institute of Certified Planners for 32 years. And if I'm running out of time, and David will tap me on the shoulder, I'll wrap in 2 minutes.
Perfect.
But I'll take a little,
3 to speak.
until that time.
He has
I-
more than that.
I can do that. You have my report, you know who my clients are, Pelican Watch Condominium Association, Edwin French III, and Thomas and Deborah Danford. You know what my qualifications are, that you have my resume, that's on the record. This is a quasi-judicial hearing. You've had a good explanation of that from your attorney. The standard is strict scrutiny, and we don't need to go farther on that. I've read and reviewed the staff reports. There are 2 of them. I want to say with all respect to staff and also to the neighborhood company that there's some things that the staff report didn't completely address. First is the adequacy or inadequacy of the owner's existing entitlements, which are the same as the residents of Pelican Watch and of Mr. French and the Danfords. These neighboring property owners contend that the applicant's future land use map designations and zoning category are appropriate entitlements for the subject property and should not be amended for that reason. Mr. Davies in fact said that the There is a substantial existing entitlement on this property. There is, and one that could be quite lucrative. Second, the staff report contains no analysis of the potential impacts of the change use on neighbors in the immediate vicinity. You've received very good testimony from Matt on that matter. The property owner said food truck parks are becoming more popular. He's absolutely right, they are. And many of us have had good experiences at them. However, it's also true from the January 9th testimony, Ms. Frankel said that there is at this time no ordinance regulating food truck parks in Fort Myers Beach. I'm going to say that that's an important observation, and that in fact there should be, especially in a community like this where residential uses and commercial uses and recreational uses are crammed right up against each other. The purpose for having an ordinance regulating food truck location and operation is that you could, as a community, make judgments about the time, place, and manner of this service. And want to briefly go to the comprehensive plan definition. I agree with Mosen that you do have a great tradition of planning here in Fort Myers Beach. I am actually old enough that I went to some of those hearings. I wasn't working for anybody, but I came to learn how a new community does its planning, and it was a great experience. But policy 4, B5, which defines boulevard, says to obtain approval for new or expanded commercial activities, which is his, proposals must be sensitive to nearby residential uses, complement any adjoining commercial uses, contribute to the public realm as described in this comprehensive plan, and meet the design concepts of this plan and the land development code. That is very much needed. And the neighbors, I know several of them wanted to address the past inadequacy of the conversation between the applicant and his neighbors. I want to say the best opportunity to do that would be in the ordinance. And I'm sorry that you won't hear more from them. They're far more eloquent on this matter than I am. The staff report, while addressing issues of compatibility, did not go to the statutory definition in section 163.3164 (9), which says compatibility means a condition in which land uses or conditions can coexist in relative proximity to each other in a stable fashion over time, such that no use or condition is unduly negatively impacted directly or indirectly by another use or condition. That's wordy, but I'm going to strongly suggest that if you have less than 1 acre, less than 0.7 acres, and it's necessary to impose 27 conditions on that 7/10 of an acre, that maybe you're trying to do too much. The staff report relied upon research performed by the applicants and the applicants' experts to apply the ordinances of nearby communities with substantially different geographies and commercial patterns. Here, this use is right next to residential. That's a difference. That's not, we have a new ordinance in Cape Coral. People are really pretty happy about it. This is a different situation.
I'm just gonna ask you to wrap up, please.
All right. I propose 8 at I want to second what Mosen said. I want to point out the numerous references that I have made to written testimony by neighbors. I wish I had time to go through all of them. I propose 8 recommended findings of fact. I will give them to you in condensed form. Finding number 1, neighboring property owners, including residents of Pelican Watch, Mr. French and the Danfords, were not afforded sufficient procedural due process and had no opportunity to engage counsel in a timely manner
No.
or cross-examine.
No, that simply isn't true. But go, if you could just keep going.
2.
Keep going.
The Fort Myers Beach Comprehensive Plan does not provide specific guidance for the siting of food truck parks, given the potential conflicts between outdoor food truck vendors and customers and their residential neighbors. Fort Myers Beach should not authorize food truck parks at this or any other location until the town has had the opportunity to avail the community and the planning of the planning process to adopt appropriate standards within the Comprehensive Plan and Land Development Code. Staff raised this matter on June 9th. Finding number 3, the proposed rezoning application is inconsistent with Fort Myers Beach Comprehensive Plan, particularly policies 4B1 and 4C3, which introduces incompatible, introduces uses incompatible with the, quote, small-town character of the community. 4, proposed development fails to meet the statutory definition of compatibility, as I referred to earlier. Number 5, the proposed rezoning fails to adequately address traffic safety concerns as Mosen addressed. Finding 6, does not meet environmental protection standards. Finding 7, procedural deficiencies, including inadequate justification for requested deviations and insufficient community engagement, fail to satisfy requirements for equitable and transparent land use decision-making. And number 8, community opposition as expressed in documented testimony from Pelican Watch residents, highlighting significant concerns, noise, aesthetics, safety impacts, underscoring the project's incompatibility with surrounding land uses.
Thank you.
I have a final thought. When it is necessary to impose 27 conditions of approval on a 7/10 acre property, you are trying to cram 10 pounds of sugar into a 5-pound bag. The applicant and the town have alternatives. As Mr. Davies said, there are significant entitlements. Thank you.
Thank you, sir. David?
Yes, I just have our agreed parties up next, and then I'll just wrap up. But I'm very conscious of the time.
I'm glad. Mr. and Mrs. Danford?
Actually, I think we've got Randy coming up.
Or Randy? Whoever it is.
Absolutely.
Thanks. I'll cut mine very short, and so we can give time to others. So just a couple of points to make. Randy Bryce, I'm an owner and president of the HOA at Pelican Watch. Just as it regards to, we had a number of signees sign up for time. All of the Pelican Watch other residents will cede their time in effort to get this done. So the couple things we heard from the last LPA meeting was to try to come to this meeting fact-based. and to make sure that we've tried to do proper engagement with the applicant. Related to the fact-based part, we heard you, and the best way we as lay people can do that is to hire the experts that we have. So otherwise, we're a little bit over our skis on a lot of this stuff as we're learning. So hopefully, our opinions can be heard through them as we've all reviewed these and agree with their reports. The other issue is relating to the engagement of the applicant. As Ken noted, we did have a call on February 4th. As these things are, they're a little testy at times, but I thought they were constructive and informative to both parties. They can agree or not to that, but I thought it was good for us to get a handle on some of the newest changes they were proposing. We do have still opposition to this development. The public parking and the amount of traffic that will dump into our neighborhood is an issue, and the noise issue, as brought up by a couple of members, LPA committee members, is a big deal to us. I was down walking home from last night from the square and went past, I think it's called We Eat at the Beach or something like that, a little food truck that's out there, and I was 150 feet away, and I could sing along to the music. We have a 7.5 foot proposed buffer to our land. That is a big deal to us. As one of our members told me when we were meeting on this, is the last time they will ever be able to sit at our pool and enjoy a book in peace and quiet is the day the food truck opens. As the last day. It's kind of a telling, interesting statement from the compatibility to the neighborhood, I think. So with that, I do agree with the other expert testimony that it feels like this would be a little bit easier if we knew what the rules were before we were making decisions. So I would encourage the LPA to take that into account, that we would like to see city ordinances in place that were done without all the deviations and conditions that are being done to try to fit this property in. And we have submitted mitigations in both our packet, and I believe that the legal representation for the applicant was provided those over the weekend in written form. So we have continued to try to suggest things that would make this property more amenable to us. And to the LPA committee and the town staff, thank you for your service to our community.
Thank you very much, Randy. Mr. and Mrs. Danford?
I too will try to be brief here. I'm Tom Danford, 2520 and 2522 Cottage Avenue. I submitted my letter on February the 4th, which details and supports my position. I want to thank the members of the LPA for allowing my presentation today, as well as your public service. For the record, I agree with and endorse all of our experts' positions expressed today in their reports, and I also want to acknowledge for the record, since Dan did, that I appreciate his and Ed's allowance of our contractors to utilize their property. We'll reciprocate if we can. Today is 867 days and multi-million dollars into our rebuilding process without any code variances, which seem to be called deviations for commercial projects. We purchased into this location because it was away from the busy commercial areas and offers quiet, peaceful enjoyment. I believe how we are rebuilding is exactly the town's vision, creating a home that embraces quiet, peaceful family enjoyment. Please safeguard this. I want to touch on beach access points. Why did Fort Myers Beach create access points with little or no public parking, such as Mango and Chapel Street? It was to allow Fort Myers Beach residents who were not oceanfront a means to enjoy the beach via pedestrian access. I embrace that concept. Is the vision rebuilding Fort Myers Beach to have commercial parking lots at every beach access point? I do not embrace access point commercialization. We have too many parking lots. As indicated by the efforts, the applicant plans to introduce significant additional transient traffic congestion to our neighborhood. It is therefore the applicant's responsibility to address congestion and contain it within their property, not pushing it out to local neighborhood streets such as Chapel. It's backwards thinking to use the Chapel Street concept because that's how the previous business did it. Since then, Fort Myers Beach has changed. Notably, Estero has undergone major improvements, yet still can't handle the traffic. I would suggest that it makes logical that the ingress egress point should be on Estero and not Chapel or Cottage. Our neighborhood will suffer significant adverse impact on our property values. Experts have indicated up to 30% adverse impact. I estimate that in excess of $75 million of property values will be adversely impacted if approved. As neighbors, we should not suffer devaluation so that the applicant can have a financial gain. In the staff report, they say the proposed uses comply with this chapter and with the town ordinances and codes, except in regards to the deviations. So essentially, it's okay, except where it's not. It would be interesting for staff to summarize how this benefits the neighborhood or even the town as a whole. In conclusion, this application with 27 conditions and 6 deviations is clearly inappropriate. It's inconsistent in material respects with the comprehensive plan, future land use, and the vision of the town. Based on these impacts to the neighborhood, the immediate neighbors, and Fort Myers Beach as a whole, I plead for the LPA to deny this application. Please stop inconsistent redevelopment of Fort Myers Beach here and now. LPA members, as the stewards of the vision of how Fort Myers Beach should be rebuilt, please be steadfast in your opportunity to shape the redevelopment of Fort Myers Beach. It will be your legacy. Thank you.
Thank you, Mr. Danford. Mrs. Danford?
God, it's been a long day already, hasn't it? Hi, I'm Deb Danford. I'm also an owner at 2520 and 2522 Cottage Avenue. I think we can all agree, food trucks and parking lots are not unique here on the island. Just drive up and down Estero. This proposal is basically just more of the same. It looks prettier, but it's more of the same. It's been almost 2.5 years since Ian. I think it's time we encourage more variety and unique permanent brick and mortar businesses on the island. Applicants state this is not a party environment, but a family environment. But I have yet to hear one benefit to us and our families as neighbors who would adversely be affected by this. We've heard from our experts today who have provided verifiable information and evidence to further support why this development doesn't belong in this location. Let me say for the record, I agree and I endorse our experts' position and reports. Our expert real estate appraiser stated our property values will see up to a 30% in land, up to a 30% reduction in land values. This doesn't even take into account the devaluation after our property is built. Where does this leave us and other residents? We are a mere 31 feet from the property line, for the applicant's property line. Applicants propose they will plant at least 2 rows of vegetation as a buffer to help mitigate the noise, food smells, etc. While it may look nice from the ground level, our first level is 20 feet up in the air. Our first bedroom window is 35 feet in the air. That's not by choice, that's required. As far as the first level. This would do nothing to mitigate noise from not just music, but traffic, crowds, food smells, permeating through our neighborhood and our homes. This is going to be a daily thing based on what we're hearing as far as their hours. What happens in the future when the applicants decide they may want to change things? They may want to play live music until midnight, host 8 food trucks, lease it out for a concert or a carnival. Where does that leave us as neighbors? It just leaves us with yet another fight to protect our neighborhood and our property rights. This development will be nothing more than a constant burden on neighbors. As detailed in my letter to the LPA, regardless of signage or what others say, we live here. We know all the problems we will be forced to deal with on a daily basis if this development were allowed in our neighborhood. That's why we're all so passionate about it. We are developers too, Tom and I are. We have nothing personally against the applicants and respect their right to develop their property, but it shouldn't be at the expense of their neighbors' property values and their investments and their rights to quiet enjoyment of their property. We purchased our property here because it was a quiet neighborhood. That was the reason why we picked it. We wanted to be away from Times Square. And we've invested a great deal to rebuild already. In conclusion, please deny this request. Please please help you protect your residents' rights. Our rights matter. Our investments matter. Thank you.
Thank you, Ms. Stanford. No, you can't, I'm sorry, you have to stop. You cannot clap. Thank you. Well, thank you, David, for pointing that out. Yes,
We got Ed French.
Mr. French.
My name is Ed French. I'm at 2548 and 2550 Cottage Avenue.
Good morning, Mr. French, or good afternoon.
Madam Chair? Yes, it is. It just turned, so I'll make it super short and brief. Start out with, though, that I certainly appreciate all the time that everybody took to come out to see the property. And really was refreshing to know that everybody was taking stock in the island like we do. Tough decisions, a lot of moving parts in this one. I'm concerned about everything that everybody's said already. I'm gonna make it super short and sweet, say I got my faith in you. I think the applicant should be able to keep it between the lines on that property, like everybody else. And thanks for the time.
Thank you, Mr. French. Yes, sir.
Good afternoon. I'm gonna try to be as brief as I can. I know it's 12:17 and I think we've got
Hold on
12:30.
1 second. I
Yes,
wanna
of course.
ask one of the members a question. Don, your phone call, is it a long one? Are you gone for the rest of the day?
Scheduled for 2 hours.
Okay.
Okay,
So,
great.
hour and
So,
a half.
Madam Chair, housekeeping, it would be possible to recess and continue 2 hours later when, Mr. Sudduth is able to rejoin us.
Yes, but then we have,
He's
you're
okay.
okay.
So it might be that we reach a nice stopping point, having heard from the interveners, and then take a recess until a time certain today.
What are your thoughts on that? Jim?
I'll make anything work.
Okay, I know what your thought is fine. Doug, what's your thought?
I'll make anything.
Okay, Jane?
I can reconvene whenever we want.
John?
Absolutely support taking the time.
Mr. Davies?
I was gonna say I'm willing to waive
Yes.
rebuttal so we can get to it now.
Yes.
I'm happy
Well,
to
we
waive
do
rebuttal.
have public comment
Oh, I know,
still.
and I'm going to allow them to speak. Okay, so,
Absolutely.
without any verbal responses, do you understand what we're saying? That we're willing to stop, just so you have a full contingent of the LPA to come to a good to come to a conclusion, good, not good, that'll be in the eyes of the beholder. Are you all willing to allow this 2-hour break? Do you agree with that?
No.
It's a lunch break.
Okay, well, it's gonna be a lunch break. I think it's in everybody's best interest for us to do this.
Okay.
Okay, go ahead.
Well,
So,
are we
you
coming
go
back?
ahead and finish, and then we're gonna stop. Do you think 10 minutes is enough for you to?
Absolutely.
Okay.
I just want to be clear. So are we coming back after a break?
Yes, we're going to
Yes.
come back after a break.
And so is there gonna be a chance for them to rebut? Because if there's gonna be a chance
Yes,
for
there
them-
is.
Well, so then, in that case, I would ask for the consideration of we cut our time incredibly short for the benefit.
I'm going to allow public comment.
Okay, and our aggrieved parties cut their comments very short as well.
If one of them would like to speak again, I'll be
Okay.
glad to hear from them.
Okay, I appreciate it. Thank
You're
you.
welcome.
Thank you very much.
So go
In
ahead.
which case, I'll hold I can hold my comments until after the break, if that's all
Okay.
right.
You all want to break right now?
What time will we be?
It's 12:20, Don?
Yeah, I'm free at 2 o'clock, so.
Okay.
Wait, what about finishing the rest of the meeting while everybody else takes a break and then all we'll have is the end? No? No? Okay.
No,
Never
because we're in the
mind.
middle of public comment, we're in the
Thank
middle
you.
of public hearing. So we are officially going to break from 12:21 until 2 PM.
Okay.
We will reconvene here at 2 PM. This hearing is still open, so please don't speak to any of the LPA members, because we've already given our disclosures, and we'll see you back here at 2 o'clock.
Thank you so much. I appreciate your
Thank you.
consideration and time. Thank you so much, and thank you to the board members who have made exceptions to the
Thank you.
schedule for our benefit. Thank you so much.
You know what?